Section 90 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John R. Kelly for the murder of David W. Oxford. Dawson, Georgia, 1871, Part 6. From the concurrent testimony of Melton, Kitchings, and Miss Reynolds, it appears, and indeed the fact is not denied, that prisoner on that day repaired to the show grounds as a spectator of a circus performance. It does not appear that he intended or even anticipated a difficulty. On the contrary, this idea is negatived by the circumstance that he took with him his wife and another female friend. These same witnesses, together with Whitten, an intelligent and truthful man, state that prisoner, on reaching the sideshow, inquired for the doorkeeper. That worthy presents himself, not with an air of becoming civility, but with a pistol in his hand, on account perhaps of the passage with Russell, an occurrence with which prisoner had no connection. Excitement and confusion were prevailing, and some of the witnesses who were nearby did not hear the whole of what was said. Two of these witnesses testify the prisoner respectfully asked to be permitted to see a friend who had gone into the show. Thereupon this gallant Sir Knight, who, according to Mr. Irvin, was there as the exemplar of politeness and the champion of the women and children, makes an insulting reply, in effect, charging prisoner with an intention to steal his way into the show. Just here, let it be remarked that the prosecution lays stress upon the fact that this circus had paid the usual taxes and that it was properly and legally there. So may it be said that prisoner went in obedience to their invitation, and that he was properly and legally there. And there is no foundation for the insinuation that he intended to steal his way into the show, for he has proven to have bought his tickets. Yet this showman charges prisoner with an intention to commit a theft, and about the same time, according to the testimony of all these witnesses, he seizes prisoner with his left hand, brandishing his pistol with his right, and calling for the gunmen. Ah, it appears that these showmen, my brother Irvin's devotees of peace and good order, were armed and equipped for the occasion. They seem to have had their squad called gunmen, ready to enter upon the work of butchery at the call of this cutthroat. Two of these gunmen readily present themselves, for these circus men are always ready for fun or fight. Thus we find the prisoner at once surrounded by three men with pistols in their hands. Be it remembered that these are facts sworn to by witnesses, whose testimonies are unimpeached. These witnesses all say that prisoner retreated, telling them that he wanted no difficulty, and imploring them not to crowd him. That prisoner did retreat is shown, not only by the testimony of the witnesses named, but by that of Mr. Avant, and also that of Mr. Young, a witness for the state. Young swore that prisoner was retreating out of the gangway before this showman, who was advancing on him in a threatening manner, and that prisoner seemed to decline a difficulty. While prisoner is retreating and declining a difficulty, the man in front of him, say these witnesses, is thrusting and pushing him backward, flourishing his pistol, boasting that he could shoot 15 times, taunting prisoner with cowardice and ordering him to leave the ground, while one of the two gunmen presents his derringer at the side of the prisoner's head and threatens, in his own expressive language, to blow hell through him. Let it still be borne in mind that, as to these facts, the witnesses for the defense are uncontradicted, except it be in one or two particulars by Mr. Solomon, who acknowledges that he was present only a part of the time, and that, owing to his deafness, he could illy understand what was said. Not only are they uncontradicted, but they are supported in the material points by Mr. Young, a reliable witness for the state. Such, gentlemen, is the dangerous position, and such the threatened surroundings of the prisoner, just at this critical juncture. Now, suppose we were to close the examination of the evidence for the defense right here, and that you should differ from me and conclude with the prosecution that the showman did not shoot first. We will even go further and adopt for a moment the unwarrantable idea of the prosecution that the showman desired peace. It must, however, be confessed that this was extraordinary conduct for men who had gone on a mission of peace. Though you may entertain this view, still, under the facts which we have already passed in review, and under the law applicable to those facts, you cannot find the defendant guilty. I invoke for your consideration, in connection with the view of the case now under discussion, another rule of law, a rule of unquestionable soundness and authority, laid down by all writers on criminal law, and incorporated into our Code 4265 in the following language. A bare fear of any of those offenses to prevent which the homicide is alleged to have been committed shall not be sufficient to justify the killing. It must appear that the circumstances were such as to excite the fears of a reasonable man, and that the party killing really acted under the influence of those fears, and not in a spirit of revenge. By way of illustration of this rule, I read you, gentlemen, from Morton's criminal law as follows. If the apprehension of an immediate and actual danger to life be sincere, though unreal, it is in like manner a defense. Although this proposition in its present shape has been accepted with great reluctance, and in very recent time by the courts, and should always be applied with extreme caution, it has at all periods been practically recognized. Thus, in one of the earliest reported English cases, where it appeared that the defendant, being in bed and asleep in his house, his maidservant, who had hired the deceased to help her to do her work, as she was going to let her out about midnight, thought she heard thieves breaking open the door, upon which she ran upstairs to her master and informed him thereof, who, rising suddenly and running downstairs, with his sword drawn, the deceased hid herself in the buttery, lest she should be discovered. The defendant's wife, observing some person there and not knowing her, but conceiving she had been a thief, cried out, "Here they be that would undo us." Thereupon the defendant ran into the buttery in the dark, not knowing the deceased, but taking her to be a thief, and thrusting with his sword before him, he killed her. This was ruled to be a misadventure. It was said in Selfridge's case that when, from the nature of the attack, there is reasonable ground for a man to believe that there is a design to destroy his life or commit any felony upon his person, the killing the assailant will be excusable homicide, although it should afterwards appear that no felony was intended. Then, gentlemen, to apply this rule to the case at bar, if the prisoner was surrounded by circumstances such as to excite the fears of a reasonable man, and he acted under the influence of those fears, even though there may have been no actual danger, though the showman may not have intended to commit a felony, still he was justifiable. Who can contemplate the situation of the prisoner just on the eve of the shooting and say that the circumstances surrounding him were not such as to excite the fears of a reasonable man? If he had the instincts and sensibilities common to men, his gravest apprehension for his personal safety must have been aroused. Then, gentlemen, in this view of the case, you are bound to acquit him. But, gentlemen of the jury, the part performed by the showman in the opening act of this bloody drama does not stop here. Would, for the sake of humanity, that it did. Then would this curtain have dropped, and we should have been spared the appalling scene that followed. But not so. These champions were determined to have a carnival of blood, armed with such formidable weapons as 15 shooters, each man a walking arsenal, and with gunmen ready to obey the summons. They were prepared for any emergency. They are eager for the fray, and not satisfied with bullying and badgering the prisoner. They opened fire upon him. Melton and Kitchings and Miss Reynolds all concur in the statement that the showman shot twice at prisoner before he shot at all, that this was a third fire, while Whitten says he thought from their conduct the showman intended to shoot, and that he turned away for his own safety, that he heard 2 shots, and looking around, he saw prisoner discharge his pistol in the air. Now, the witness for the state agreed that prisoner's first shot was in the air. The 2 shots heard and not seen by Whitten must, therefore, have been fired by the showman. Avant corroborates this view of the case when he says that the first shot passed near him, that the second shot was turned into the ground by a stroke by Charles A. Kelly's hand, that neither of these was shot by the Kellys, and that thereupon he saw prisoner draw his pistol and shoot in the air. And let it be remembered that Gamage and Miller and William B. Oxford were all the same distance away, the intervening crowd obstructing their view, and while they testify the prisoner fired the first shot, witnessed by them, they do not positively swear that no shots were fired before they saw prisoner shoot in the air. And just here, gentlemen, we invoke that rule which is so well founded in reason and settled in law, that positive evidence is to be believed rather than that which is merely negative. The testimony of a witness swearing positively to a fact is to be acted on rather than that of one who does not know of the existence of that fact. Thus, gentlemen, we have the circumstances under which prisoner commenced to shoot. Was it not time for him to strike in his own defense? Had not forbearance ceased to be a virtue? Could he have had the impulses and feelings of man and endured more? But it is urged by the prosecution that the prisoner had a pistol, and that fact is paraded as a circumstance to show malice. And pray, did not the showmen all have pistols? Was it any more a circumstance of malice in the prisoner than in the showman? It might be safely asserted that 2/3 of the men present on that occasion had pistols, yet it will not be pretended that they were all felons. In the cases cited of Monroe v. State and of Keener v. State, both men were armed, still they were not on that account condemned. Is the prisoner to be singled out and treated as a felon, or even prejudiced because he had put himself on a footing of defense against those who made upon him an unprovoked and deadly assault? Again, it is said that the Kellys had an affray to the terror of the good people there assembled. True it is, there was terror, but who inspired it? Not the Kellys. Why, the very first scene in this tragedy was when one of these men, whom my brother Irvin lauds as the champions of the women and children rudely, seized Mrs. Russell and hurled her with such force as would have sent her prone upon the earth but for the intervention of her husband. Gallant conduct, indeed. Why, we in this country have been accustomed to regard tenderness and respect of the gentler sex as the sublimest feature of our civilization, but it is reserved for these champions to trample such considerations underfoot, and in doing so they are so fortunate to have the fine abilities of my brother Irvin brought into requisition for their defense. The next we hear of this terror is from Mr. Young, who turned and walked away because he believed from the manner of the man who approached with the derringer that he intended to shoot prisoner. Whitten tells you that he and the crowd turned off, and that he did so because he believed from their threats and manner that the showman would shoot prisoner. Were not these circumstances such as to excite the fears of a reasonable man? The evidence shows that they did excite the fears, not only of prisoner, but the assembled multitude. So, gentlemen, terror and confusion did prevail on that occasion, but it was caused by the conduct of the showman. Let us for a moment review the savage conduct of these showmen, and the frightful position in which the prisoner is thereby placed. In reply to a polite request, prisoner is accused of an intention to steal his way into the show. From regard to the time and place, He submits to an insult which under other circumstances he would have resented. He is then violently seized by a man with a drawn pistol, who boasts that he can shoot 15 times, commands him to leave the ground, and taunts him with cowardice, a degrading insinuation which the feelings of a true man instinctively repel. Prisoner endured this insult also, but when his own safety, the preservation of his life, demanded of him to act, he wrote the falsehood on the crest of his assailant, and showed him that the man who faced death on the glory plains of Chickamauga was no coward. This ruffian then sounds the slogan by calling for the gunmen. They appear with their arms. Prisoner retreats, declines the contest, and asks for quarter. One thrusts him back, brandishing his pistol with hideous threats, while another, presenting a derringer at the side of his head, undertakes to blow hell through him. Not content with these demoniacal threats, and with following up a retreating victim, they attempt his death by twice shooting at him. I think, gentlemen, you will agree with me when I say that the prisoner would have been more or less than mortal man if he had not shot in his own defense. But, gentlemen of the jury, we have argued this case on the assumption that the prisoner fired the fatal shot. That fact, however, has not been proven. It is not pretended that it is sustained by positive evidence. Do the facts proven come up to the requirements of the test rule on the subject of circumstantial evidence? That rule, as stated by the writers on evidence, is as follows. In order to convict a prisoner on the evidence of circumstances, it is held necessary not only that the circumstances all concur to show that he committed the crime, but that they all be inconsistent with any other rational conclusion. Now, are all the circumstances of this case inconsistent with every other rational conclusion, except that of the guilt of the prisoner? Can we remember the 16 balls testified to by Avant, and conclude that deceased must have come to his death by one of the 5 shots by prisoner, and that he could not have been killed by one of the other 11? But, gentlemen, we have circumstantial and positive evidence sufficient to produce a conviction, amounting to moral certainty at least, that the prisoner did not perpetrate the killing. It is insisted by the prosecution that Oxford was shot while the showmen were passing under the canvas, the position of deceased when he fell, and all the witnesses who know anything of his exit show that he passed out under the southwestern part of the canvas. Indeed, this is not denied. Now, the witnesses for the state, viz., Gamache, Clark, W.B. Oxford, and Miller, all agree that the Kellys were facing and firing in a southeast direction when the showmen were under the canvas. They, occupying a position northeast from deceased and firing in a southeast direction, could not have hit him. But take the testimony of Young, who, at prisoner's third shot, started home, and having moved in a fast walk about 20 paces, discovered deceased lying about the same distance from the canvas. From this we draw the reasonable and irresistible conclusion that if deceased was shot while passing under the canvas, as the prosecution admits and contends he was, then he must have received his death wound during the time, at least, a prisoner was firing the 3 shots testified to by Young. But that witness accounts for those 3 shots, showing the first to have gone up in the air, the second down into the ground, and the third in an easterly direction through the picture canvas. So that from this testimony the conclusion is clear and inevitable that, while David W. Oxford must have been wounded during the time of firing a prisoner's first 3 shots, neither of those shots could possibly have taken effect upon his person. Further, gentlemen, if the jury records of your court speak the truth, deceased was shot by Charles A. Kelly, who has already been convicted of the offense. But we are told that the prisoner and Charles A. Kelly were moved by a common intent to commit a felony, and that the act of one is the act of both. This seems to be the burden of the prosecution. The evidence does not support that doctrine, nor warrant such a conclusion. On the contrary, there is a signal absence of any common design or concert of action. They did not visit the show together, nor does it appear that they had met on that day, until we find Charles A. Kelly not seeking to provoke a difficulty in pursuance of a common intent, but actuated by the praiseworthy instincts of a brother, trying to extricate prisoner from a position of extreme peril, and to lead him away from the scene of approaching trouble. He was there in the interest of good order. He held forth the olive branch of peace. The peace offering was spurned by the assailants who breathed out threatenings and slaughter against their intended victim, pursued their murderous design until the Kellys were forced to act in self-defense. And this is what counsel for the state is pleased to call a case of common intent to commit a felony. There is not the slightest foundation for this theory of the prosecution, unless it be the fact that both the Kellys happen to be present. But mere presence and even participation is not evidence of a common felonious design. I will, at the expense of being tedious, submit for your consideration some authorities on that subject, authorities which, in view of the evidence of this case, will effectually refute such an argument. And first I will read you from Wharton's American Criminal Law. While all who are present, siding and abetting with him who inflicts the mortal blow in case of murder, are principals and criminals in the highest degree, is not every intermeddling in a quarrel or a fray, from which death ensues, that constitutes an aiding or abetting to the murder. If, for instance, two men fight on a former grudge and of settled malice, and with intent to kill, of which the spectators are innocent, and they, of a sudden, take sides with the combatants, and encourage them by words, and death ensues, it will not be murder in such persons. I read you next Roscoe's Criminal Evidence, pages 213 to 214. So a mere participation in the act without a felonious participation in the design will not be sufficient. 1 East PC 257, Plummer's Case, Kell 109. Thus, if a master assault another with malice pretense, and the servant, ignorant of his master's felonious design, take part with and kill the other, it is manslaughter in the servant and murder in the master. 1 Hale 466. Where several persons are in company together engaged in one common purpose, lawful or unlawful, and one of them, without the knowledge or consent of the others, commits an offense, the others will not be involved in this guilt, unless the act done was in some manner in furtherance of the common intention. The next authority is Russell on Crimes, page 29. If a fact amounting to murder should be committed in prosecution of some unlawful purpose, though it were but a bare trespass, all persons who had gone in order to give assistance, if need were, but carrying such unlawful purpose into execution, would be guilty of murder. But this will apply only to a case where the murder was committed in prosecution of some unlawful purpose, some common design in which the combining parties were united, and for the effecting whereof they had assembled. For unless this shall appear, though the person giving the mortal blow may himself be guilty of murder or manslaughter, yet the others who came together for a different purpose will not be involved in his guilt. Now, the evidence shows that the Kellys did not come together on that day with a common felonious design, nor for an unlawful purpose, and hence this theory of the prosecution must fall to the ground. The same doctrine is laid down by our Supreme Court in the case of Brown v. State 28, Georgia. Presence and participation in the act of killing a human being is not evidence of consent and concurrence in the perpetration of the act by a defendant, charged as aiding and abetting in the killing, unless he had a felonious design, or participated in the felonious design of the person killing. The accident that both were present, therefore, is not sufficient. Indeed, if, as the evidence shows, they acted in self-defense, or if Charles A. Kelly was acting to prevent a felony upon the person of his brother, as it was his duty to do, then this at once dissipates and precludes the idea and agency of a common felonious intent. But, gentlemen, there is to the prisoner cause of congratulations that we are not left in doubt as to who was the slayer of David W. Oxford. The perpetrator of this bloody deed is declared by evidence, unmistakable as it is unimpeachable. In the testimony of William B. Russell, the mystery is explained. By that testimony, a rift is made in the cloud that enveloped this sad occurrence, and through that rift, the bow of promise greets the eye of the prisoner, and of that gray-haired sire who, grief-stricken and oppressed with care, has hovered with paternal interest around this bar throughout all these trials. That old man could not believe that his son, reared as he was in the household of Christianity and in the atmosphere of piety, could willfully and maliciously shed the blood of his fellow man. It would be to contradict the venerable teachings of the wisest of men. Train up a child in the way he should go, and when he is old he will not depart from it. He had an abiding faith in the innocence of his boy, and under the inspiration of that faith, he has from time to time brought him forth to offer him up, if need be, upon the altar of justice, as Abraham was about to offer up Isaac. But as that patriarch found a substitute to offer up as a burnt offering, so the evidence in this case furnishes a substitute in the person of the man who Russell saw standing inside the canvas near the door. Russell swears that while he was in a stooping posture, holding the canvas for his family to pass out, and while deceased was passing out behind him, hearing a sound as if a ball striking some object near him, he cast his eyes in the direction of the door, where he saw the same showman whom he had met in the entrance, lowering his pistol as if he had just fired it, that the pistol was pointing with a volume of smoke before it, in the direction of deceased and himself. But this evidence does not suit the palate of the counsel for the prosecution, and that gentleman, with a flourish of trumpets, makes a terrible onslaught at all the witnesses for the defense, and gives us to understand that he intends to devour poor Russell. Ah, has it come to this? Is this the temper of the prosecution, that witnesses, honest men and true, are to have their integrity arraigned and their characters blasted, because, forsooth, they happen to know facts that do not chime in with the bloody theory of the prosecution? Upon what meat doth this our Caesar feed, that he has come to be a destroyer of men, because they happen not to be upon his line of action? I have much respect for the gentleman. I esteem him for his many good qualities of head and heart, but in this case he exhibits a want of charity that is very much at variance with his uniformly Christian character. I commend him to more forbearance. Why, gentlemen, we of the defense endeavor to harmonize our action with the spirit of the law, and to make all witnesses speak truly. We believe that each one told the tale as he understood it, but men, occupying different standpoints, do not see alike. We thank the gentleman for his warning, so that Russell can prepare to meet his fate, or in the language of the gentleman, to be cut up into trigger meat. It remains to be seen whether the achievement shall come up to the lofty and sounding phrase of the manifesto. Many of you are personally acquainted with Russell. He is known and respected in the community in which he lives as a man of truth and veracity. He has no bias in favor of prisoner. On the contrary, the deceased was the brother of his wife. He delivered his testimony with the manner of a man conscious of the truth of his statement. Again, the mind looks out in quest of a motive for action. In this instance, we have the motive. The man standing inside the canvas near the door is identified as the man who had the difficulty with Russell at the entrance. His passions were aroused. He had a supposed wrong to avenge. Seeing Russell, his adversary, at the opposite side of the canvas, he fires at him and hits deceased, who is by his side. There is a rational solution of the matter. And you will bear in mind that the testimony of Russell is well supported and corroborated in every material point. The other witnesses agree with him as to the description of the man with whom he had the difficulty in the doorway. Young and W.B. Oxford and Miller, as well as the witness for the defense, all swear that Russell, with his family and deceased, passed on into the show. Mrs. Russell corroborates him as to what took place while they were inside the canvas. She, too, shows that she and her husband and children and her brother, the deceased, all passed out onto the canvas about the same time and place, and that deceased discovered the first sign of his wound as it came out. The character of the wound and the range of the ball, as testified to by Dr. Price, show that deceased must have received the ball whilst in a stooping position, all of which supports the evidence of Russell in every important particular. Then, gentlemen, the blood of poor Oxford cries for vengeance, not against the prisoner, but against the showman, who is proven to have been the murderer. End of section 90. Section 91 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John R. Kelly for the murder of David W. Oxford. Dawson, Georgia, 1871, Part 7. Now, gentlemen of the jury, I have submitted to you the law. For in criminal trials you are judges of the law, as well as of the facts. I have reviewed the evidence in the material points at least. But there is one other principle which the law, in its humanity, has adopted for the government of juries in criminal cases. If you have any reasonable doubt as to the guilt of the prisoner, then you are to give him the benefit of that doubt. This rule is so clearly and succinctly stated by our Supreme Court in the case of Mitchell v. State, 22 Georgia 235, that I read you a portion of the opinion of the court as follows. After all the exposition by text writers and illustrations by this and other courts, the simple rule is that jurors must not convict without plain and manifest proof of the prisoner's guilt, and that, entrusted as they are with the administration of public justice, on the one hand, and with the life, the liberty, and the honor of the prisoner on the other, their duty calls on them, before they pronounce a verdict of condemnation, to ask themselves whether they are satisfied beyond a reasonable doubt that the accused is guilty of the charge alleged against him in the indictment. So, gentlemen, this beneficent rule of the law will serve as a beacon light to lead you out of the embarrassment of difficulty and doubt into the haven of safety. You must be satisfied beyond all reasonable doubt of the guilt of the prisoner before you can convict. The state of Georgia does not want the blood of an innocent victim to smoke upon her altars, and hence when there is doubt and uncertainty as to the guilt of the accused, the law steps in to absolve him from earthly tribunals and leaves him for ultimate trial by that infallible judge, who reigns and rules in the circuit of the heavens. Who made the heart? 'Tis he alone. Decidedly can try us. He knows each chord its various tone, each spring its various bias. Then, if the balance let's be mute, we never can adjust it. What's done we partly may compute, but know not what's resisted. Whenever doubts disturb the equipoise of the judgment, leave the question to be determined by the searcher of all hearts. If you have a reasonable doubt as to any material point in this case, it is your duty to acquit. Here, then, at least, the prisoner may anchor in safety. Who can survey the evidence in this case and with his hand upon his heart, free from all bias and prejudice, say that he has no reasonable doubt as to whether prisoner fired the fatal shot, or if he did so, whether or not he was acting strictly in conformity to the dictates of self-defense. If you have such doubts, and have them you must, you will accord to the prisoner the benefit of them, for in such cases the law does not require frail and erring men, who dwell in houses of clay, to pass harsh judgment on an unfortunate fellow creature. Then, gentlemen, the destiny of the prisoner is in your hands. He is a young man, just past the threshold of manhood. All his hopes of future years, the last days of his old father, whose gray hairs are well nigh brought down with sorrow to the grave, the happiness of his young wife, and the character and welfare of his infant child, all are suspended upon your verdict. That verdict will either restore him to his family or crush with agony their bleeding hearts. As faithful ministers, you will discharge your duty with reference to the great responsibility that rests upon you. As intelligent men, you will not allow your minds to be diverted from the real issue in this case, neither by the ingenuity nor eloquence of counsel. The energy and zeal of the state's counsel are liberally rewarded with the people's money. Such inducements are calculated to incite to extraordinary effort. But you, gentlemen, have no blood money to urge you to a verdict of conviction, nor to canker your consciences with the sense of outrage to condemned innocence, nor will you be frightened from your propriety by the dismal echoes of that hue and cry against the prevalence of crime, which proceeds from the mouth of the prosecution. You are not now on a mission to reform the world, and if you were, you could not effect such a purpose by cruel and vindictive punishments. After all, we have to take things pretty much as we find them. We are creatures of a moment. We live out our brief hour and pass away. But the world moves on in the mighty course marked out by the great hand of destiny. The first man that was born into the world slew the second. Men in all ages have killed each other, and this state of things will probably continue as long as human nature shall perpetuate its passions, frailties, and infirmities. As good citizens, you will exert your utmost in behalf of peace and order. As sworn jurors, you will confine yourselves to the issue of facts submitted for your consideration. You will determine that issue by the evidence construed in the light of those wise and humane rules which the law has established for your guidance. In doing so, we believe that you will find the defendant not guilty of the charge alleged against him, and we are confident that such a verdict would be in consonance with those eternal principles of truth and justice which shall survive the reeks of matter and the crush of worlds, and endure in perennial freshness when time shall be no more. Mr. Irvin's closing argument for the state. Mr. Irvin: Gentlemen of the jury, my brother Harper, in his opening remarks, very appropriately said that this was a solemn case. It is a solemn case, gentlemen, and God forbid that I should say or do anything to detract from its solemnity. When a man is upon trial for his life, when even his liberty alone hangs trembling in the balance, it affords food for solemn reflection to all, but more especially to counsel, to juries, and to the judge constituting the court, which is to pass upon the issue, involving to him the loss of either life or liberty. But, gentlemen, this is also a solemn hour, as well as a solemn proceeding. Night, sable goddess, from her ebon throne in rayless majesty, now stretches forth her leaden scepter o'er a slumbering world. The little birds, which but a few short hours ago sang so sweetly in yonder groves, have folded their silent wings and gone to nest amid the branches which they made vocal with their innocent warblings. The lowing herd, which at nightfall wound slowly o'er the lea, now chew the cud of contentment and repose in their master's barnyard. Their tinkling bells are no longer heard upon the green meadow, or beside the refreshing water. The plowman, who at eventide plodded homeward his weary way, now forgetful of his toil, is locked in the arms of peaceful slumber, and gathering strength from repose with the labors of tomorrow. Your little children and my little children have long ere this hour lisped their evening orisons at their mother's knee and laid them down to that sweet refreshing sleep which innocent, happy, blessed childhood only can enjoy. No thought or dream of tomorrow's duties or responsibilities can disturb their calm repose. My own wife, far away, does not expect my return this night, but even at this late hour your helpmeets at home may be listening in expectation of your coming, and wondering why your accustomed step is not heard in the silent hall. Silence, how dead, and darkness, how profound. Creation sleeps. Yet, gentlemen of the jury, tired nature's sweet restorer, balmy sleep, comes not to your eyelids nor mine. And why? Simply because we have important duties to perform, duties which involve not only the life and liberty of our fellow man, but which also involve the best interests of society. Duties which, though onerous, must be performed by us. If we perform them in the fear of God, if we rise superior to our poor, depraved, fallen natures, and asking divine guidance and direction, follow where it leads and conscientiously perform our allotted tasks, it will be well with us, well with society, and well with our state, whatever may be the result of our labors as affecting the interest of the prisoner at the bar. Why do we see this courtroom crowded with spectators this night? Why is so much interest manifested in these proceedings? Why has so much time been consumed in this investigation? A stranger might inquire, what is this all about? I answer, on the 2nd day of November in the year 1870, a bloody tragedy was enacted in this county and town. Bills had been posted announcing that a show would be here on that day. But this part of the performance was not on the bills. 2 human beings were hurried into eternity. One of them, David W. Oxford, a simple spectator, innocent of any offense against the laws of his country, with his tender, delicate child in his arms, anxious for its safety, attempts to get beyond the reach of murderous bullets. In the act of doing so, he receives the fatal shot and falls with his arms still firmly clasped around the little helpless one, as though even in death he would shield it, and in dying covers it with his heart's blood, which gushed in crimson torrents from his mouth. We are here to inquire how he came to his death, by whose hand he fell, and bring his slayer to punishment. John R. Kelly, the prisoner at the bar, is accused of his murder and is now on trial. His counsel, my brethren, Harper and Wooten, have both made earnest, eloquent appeals to you in his behalf, and have asked you to hear his wife, his child, his father, and his mother, pleading for a husband, a father, and a son. Had I the power of the autocrat of all Russias tonight, could I, by a single word of mine, say to his guards, loose him and let him go, I would turn to that mother and say to her, take your son back again to your embrace. I would say to that old gray-haired father, receive your boy. Oh, would that I could say, innocent and pure as when you first received him from his mother's arms. I would say to his gentle, tender, loving wife, take your husband, throw around him the mantle of your own purity, shield him by your love from further harm. May he profit by this sad, sad lesson, and go and sin no more. It would afford me infinite pleasure to do this, and to also gladden the heart of that little prattler counsel have so eloquently pleaded for, and say to it, take your father back to his home in your love, and from this good hour may he be to you what nature intended he should be, a faithful monitor, protector, guardian, and friend. But, gentlemen, I have not that power. Neither is that power lodged in you, or in the judge upon the bench. I have no doubt, but as men you sympathize with the prisoner, his family and his friends, but as jurors. You must be strangers to that feeling. I thank God that, as a man, I do feel a sympathy, warm and heartfelt, for any of my race in affliction, although that affliction may be brought upon them by their own fault. Yet, as a lawyer, as counsel for the state, to uphold her dignity and to vindicate the majesty of her laws, I must say to sympathy, get thee behind me. I must know nothing. I must yield to nothing but duty, stern and inflexible duty, and you must be influenced by the same feelings as I know you will be. If sympathy could influence us, gentlemen, our sympathies might be excited adverse to the prisoner. I have seen another aged father, whose hair is silvered over with the frost of 60 or 70 winters, watching with intense interest the result of this trial. He has been deprived of the prop and stay of his declining years. His firstborn, perhaps, has been cut down in the pride of his manhood, when life was just putting out before him her most alluring charms and beckoning him on to wealth and happiness. One who a few short months ago was a happy wife, looking forward to many years of companionship with him, whom she had chosen for a partner in life's journey, who now mourns in sadness and desolation over the loved and lost. That helpless little child has been deprived of the strong arm of its father, to shield and defend it, of his succor and support in tender infancy, his guidance and direction in its mature years. Instead of the cheerful home, the wife happy in the love of her husband, and the prattling child basking in the sunshine of its father's presence, there is a desolate hearthstone, from which the passing breeze sweeps away the wail of the widow and the cry of the orphan, mingled with the moans of anguish wrung from the breast of the gray-haired sire. Let their voices, as well as the stern mandates of a violated law, be heard in connection with the pleadings of the prisoner's wife, child, father, and mother, to which counsel for the defense has so eloquently directed your attention, but heard only to counteract sympathy for and not to excite prejudices against the prisoner. My brethren for the defense have advanced many specious arguments. They have alternately assailed the citadel of your sympathies, your passions, and your prejudices. Sometimes during their arguments I was at a loss which most to admire, their eloquence in their appeals to you, or their adroitness in distorting the evidence and in trying to make the worse the better part appear. I admired the skill of advocate, while I condemned its exhibition in a case like this. Truth, eternal, immutable truth, is the object of our search. I join my brother Harper most cordially in his invocation to you. He told you to put this case into the crucible of truth, and so say I. Apply to this volume of evidence, not the evidence of the gentleman, but they commented on Mitch's evidence that was not evidence, of the evidence of the witnesses as given from the stand, the fires of an enlightened reason and of a just and impartial analysis. Let the dross of falsehood, if any there is, be consumed, and the pure gold of truth alone remain, to influence your judgment in making up your finding. I want no facts before you, gentlemen, on my own manufacture. If the evidence of the witnesses does not convict this man, in God's name, I say, acquit him. And when I come to the testimony, I ask the gentleman, as a favor to me, to correct me if I misquote it, or tell you that anything is in evidence which is not. But, gentlemen of the jury, my brother Wooten, in his zeal for his client, so proper to taunt me as the representative of Mr. Bullock, the man who pardons crime with a lavish hand, but persecutes instead or prosecutes the prisoner at the bar. I am not here as the representative of Governor Bullock, but as the representative of our good old mother, the state of Georgia. 'Tis true, she is my adopted state, but none the less dear to me. For more than 28 years she has afforded me the protection of her laws. Over 20 years ago, on the morning of the first day of my marriage, she opened her arms to welcome her I called wife, dearer to me than all the world beside. My children have been born on her soil, and she is to them their natural political mother. She has afforded them and me the means of subsistence and the blessings of liberty, home, and friends. All that I am and have and hope to be, I owe to Georgia. God bless her. 10 years ago, when her honor was assailed and her equality in the Union denied, she called upon me to buckle on my sword and go forth in her defense. I went in obedience to her call, and on the soil of the Old Dominion met those she then called her foes, leaving to her protection during my absence my wife and little ones. I returned and found she had been true to her trust. They had all been kept in safety, under the shadow of her wings, and by the blessing of the Almighty. She has called upon me now to appear in vindication of her laws, and to uphold her majesty and dignity. When Georgia calls, I ask not who controls the seal of her executive department. When her governor speaks in line of his duty, she speaks and I obey. Palsied be this good right arm when I refuse to wield it in her defense, and lifeless be this tongue when I cease to use it at her bidding, in vindication of her honor, or to uphold and maintain her laws. Then I throw to the breeze this night the proud banner of the state of Georgia, inscribed with wisdom, justice, and moderation. And I ask you, gentlemen of the jury, to adopt her motto as your motto. Be wise in your counsels, moderate in your deliberations, and just in your conclusions. But the gentleman has also taunted me and sought to excite your prejudices against me, while commending my zeal in the prosecution by accusing me of working for blood money. Is it a crime for me to work for my state? If, at her bidding, I try to bring murderers to justice, am I to be taunted with the cry of blood money? Our good old mother is no niggard. I expect to be paid for my services, and you will say, all will say, that I ought to be paid if I do my duty. I ought not to be paid. I do not deserve to be paid if I do not do my whole duty. I have in my zeal, which the gentleman has been pleased so graciously to commend, but to so intermix with covert censure as to destroy the value of the commendation, tried only to do my duty and nothing but my duty. The laborer is worthy of his hire, says the book of all books, and does my brother Wooten gainsay it? Is he not to feed counsel? Does he not work for pay? Is he any the less worthy because he expects compensation for his services to the prisoner? All I have to say is that if he is not paid, he ought to be, and he expects to be, and he will be. Then why this attack upon me? If I sought pay for services not faithfully rendered, I should not only be liable to censure, but absolutely dishonest and deserving of the anathemas of every honest man. In my opening remarks, I was particularly careful to say nothing calculated to excite prejudice against the prisoner. I did hope the gentleman would emulate my example and argue the case calmly upon the law and the facts without trying to excite prejudices or passions in your breasts. I always feel shocked when I hear counsel representing the state uttering invectives against a poor unfortunate prisoner on trial. Such appeals are beneath the dignity of a great state, and when I hear them made, I feel that the mantle of justice is trailing in the dust. Counsel have assailed me, have assailed the governor, have assailed the showmen by calling them cutthroats, thieves, and scoundrels, and myself in connection with them by calling me their champion, as if to provoke me to descend from the lofty eminence upon which I placed myself in the opening of this case. But, gentlemen, nothing shall move me from my purpose. I defy all their taunts. Nothing shall tempt me to utter one word of invective against the prisoner at the bar, except such just and legitimate conclusions as I may draw from the evidence in the case, and then not in anger and not in bitterness toward him. He stands before you this night pure and innocent as the babe at its mother's breast. Unless this volume of evidence shall justify you in stripping from him the robe of innocence and clothing him in the garb of a felon. Until your verdict is pronounced, every hair of his head is sacred. But you have been told that I shall tell you of crime rampant in the land, and the necessity of its suppression. There is no evidence before you of any other crime having been committed in all the land, save this one. Then, for the purposes of this trial, I tell you to consider that David W. Oxford was the only person ever killed by violence in Terrell County. If the prisoner is responsible for his death, judging him by the evidence alone, in manner and form as charged in this indictment, so find him. If not, so find, and I shall be satisfied. End of section 91. Section 92 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John R. Kelly for the murder of David W. Oxford, Dawson, Georgia, 1871, Part 8. But the bill of indictment has also been assailed before you. My brother Harper says it charges prisoner with killing Ames, shooting the albino woman, carrying concealed weapons, carrying weapons, raising a riot, and an affray. My brother Wooten has been pleased to call it a multifarious document, not only charging the prisoner with the murder of David W. Oxford, but it is sought to prejudice an unfortunate man in the estimation of the country by imputing to him numerous offenses, for which he is not now on trial, and then asks with Websterian emphasis, addressing me instead of the jury, if it is intended thus to outlaw the prisoner. Well, gentlemen, all the reply I have to make is that this is the first time I ever knew exceptions to a bill of indictment taken and argued before a jury. I have always been taught that the court was the proper person to hear and determine all such questions. As they took no exceptions before the court, I congratulated myself with the hope that the pleadings were all right. It seems that I was mistaken. Well, I suppose I must live and learn. But it has remained for the gentleman to teach me a lesson I have never learned from the books. The bill of indictment, gentlemen, is simply an accusation made by the grand jury without which no man can be placed upon trial for his life. The state charges that this crime, the murder of Oxford, was perpetrated under aggravated circumstances, that it differs in its main features from ordinary cases of homicide, and is not only right, but is an act of mercy to the prisoner to put him upon notice of those aggravating circumstances which the state intends to use against him. Again, the state can prove nothing but what it charges. If there are peculiar circumstances under which a crime is committed, which add to its enormity, those circumstances should be distinctly set out in the indictment. And that is just what we have done in this case. Our last legislature, in view of the many homicides resulting from men going armed to places of public gathering, sought to remedy the evil by prohibiting the carrying of arms, either concealed or openly, to any public gathering of the people, except to militia muster grounds. It was, therefore, an aggravating circumstance in this homicide that these men went to a peaceful assemblage of the people of this state, armed, not only in violation of, but in defiance of the law which commanded them not to do so. It was also an aggravation of their offense that they commenced an affray in a public place, to the terror of the citizens and disturbance of the public tranquility. You are not trying them for either of those minor offenses, however, but you are to take the facts proving the commission of those minor offenses by them into consideration, in connection with the facts proving the commission of the homicide by them, if proven as circumstances of aggravation, and as going to establish the charge of malice, the main ingredient in the crime of murder. I pronounce no judgment of outlawry upon the prisoner, further than his acts outlaw him. He does not deny that he went there armed, but they say the law is unconstitutional, that the Constitution gives to every man the right to bear arms. I may add that this is the first time I ever heard the constitutionality of the law assailed before a jury. It is your duty to obey and enforce the laws, not to make or unmake them. Their constitutionality must be passed upon, and if void, declared so by a different tribunal. But I say that this is not only a constitutional law, but a good law, and if it had been obeyed by the prisoner on the 2nd day of November last, he would have been spared the anguish of Cain, to which allusion has been made, and you and I the tedious and laborious duties which we are now performing. The country would have been spared the expense of his trial, and the public the shock occasioned by this carnival of blood, resulting from the violation of this little law, as it has been in the argument derisively termed. But they say the showmen were armed, and I, their champion, do not condemn them. The showmen are not on trial, gentlemen, and I am not their champion, but I am prepared to show that they were not guilty of violating this law on that day, by being armed at that time, and under the circumstances as developed by the evidence. You and I and every man have the right to keep arms at our homes for the defense of life, family, guests, and habitation. The offense is having and carrying about the person any dirk, bowie knife, pistol, etc., or any kind of deadly weapon to any court of justice, or any election ground or precinct or any place of public worship, or any other public gathering in this state, except militia muster grounds, until the doorkeeper was assaulted and driven away from his post by Russell, with his pistol drawn and threatening to shoot him, until the two Kellys took part in the difficulty, and John R. had his pistol also drawn. No showman was seen with the pistol. They went off and got them. They did not have them on their persons. The first pistol in the hands of a showman seen by any of the state's witnesses was a small derringer in the hands of Colonel Ames. Where did he get it from? Avant, one of the witnesses for the defense tells you. He got it out of a drawer in the ticket wagon. He kept arms for defense, not offense, just as you have a right to keep a pistol in a drawer in your house to defend your habitations against burglars, or your person or family against anyone seeking to commit a felony upon either. Ames, having complied with the law imposing a tax upon such exhibitions by the payment of $25 to the state and $25 to the town, had a right to be just where he was. That showground on that day was his castle, as much so as either of your houses where your families reside is yours, gentlemen of the jury. It was also his right to defend himself and his servants when assailed in the manner they were. It was his solemn duty, enjoined by all the rights of hospitality, to protect and defend the helpless women and children and other guests who had assembled there on that day to witness the performance. The danger to women and children was the first thought that entered the mind of the lamented Ames. Hear him in the language of one of the witnesses, addressing the assailants. Put up your pistols. This is no place to raise a row. You will scare the women and children, but you cannot scare us. But no. Appeals to them upon such grounds fell upon ears deaf to the pleadings of humanity. Much less could they be moved from their purpose by a suggestion that they would scare women and children. But my brother Wooten refers to the difficulty between Russell and the doorkeeper, and clinging to Russell's history of that transaction with all the tenacity of a drowning man to his last blank, exclaims with well-feigned indignation that the very first scene in this tragedy was when one of these men, whom my brother Irvin lauds as the champion of the women and children, rudely seized Mrs. Russell and hurled her with such force as would have sent her prone upon the earth, but for the interference of her husband. Gallant conduct indeed, he cries. Well, I will pay my respects to Mr. Russell after a while. I will only say now that Russell's evidence upon that point is not only wholly unsustained and uncorroborated by any other witness, but contradicted by every other witness worthy of belief. Young said that Russell had his pistol drawn on the doorkeeper, that the doorkeeper had his hand extended towards him, offering friendship, apologizing and saying he had intended no insult. Mrs. Russell at the same time having hold of her husband and trying to prevail on him not to have a difficulty. Miller says that, as he passed out of the sideshow, Russell had his pistol in his hand, punching the doorkeeper in the breast and threatening to shoot him. That Mrs. Russell had hold of Russell, that the doorkeeper had his hand extended, with money in it offering friendship. Strange that Mrs. Russell should have been so anxious to keep her husband from shooting the doorkeeper, if he had just previously so rudely and so grossly insulted her. Solomon corroborates both Young and Miller, and says further that Russell not only had a pistol, but that he fired it in the melee, and yet both Russell and Mrs. Russell swear positively that he did not have a pistol. If his memory is so treacherous on this point, is he to be believed on the other, uncorroborated and unsustained by a single uninterested witness? As to Mrs. Russell, it is natural that she should try and sustain her husband. Gentlemen, is she not also completely under his influence? She sees just as he would have her see. She is a part of himself. But gentlemen, even her evidence, taken altogether, does not sustain him. You will remember that on some points there was a wide difference in their version of the whole affair. Unfortunate wife! She ought not to have been brought into court to prop up the testimony of such a witness. But I say that if the doorkeeper had rudely pulled or pushed Mrs. Russell, as the counsel would have you believe, well, his conduct would have been highly reprehensible, even in the opinion of one whom the counsel has been pleased to dub as his champion. He offered a humble apology for the act, which should have been received as satisfactory, and if not sufficiently so, I say that was not the time nor the place to have avenged it, and I maintain further that the prisoner John R. Kelly is without a shadow of justification for his interference in a difficulty of Russell's own seeking, in such a place and at such a time. He would have been without excuse for his acts on that occasion, at any place or at any time. 'Tis true they tried to make it appear that he was also insulted and bullied by this ruffianly doorkeeper, who, according to my brother Wooten's theory, was eager for the fray, and thirsting for a carnival of blood. But I will show you, gentlemen, when I came to the evidence, and demonstrate to your satisfaction that such was not the case. They would have you believe that this man, who was so prompt to write the falsehood on the crest of his assailant, was insulted by the showman in response to a polite request that he might see someone inside the show. But unfortunately for him, the same witness, or one of them, upon whom he relies with his plea of justification, says that John R. Kelly bought tickets to take his family into the sideshow. Then, if he had bought the tickets to go in, why did he not go in, instead of asking the doorkeeper to let him pass in to see a man inside? Ah, gentlemen, that theory won't do. John R. Kelly came to that door to take up the difficulty the valiant Mr. Russell had so unnecessarily commenced. The man who faced death on the gory plains of Chickamauga was no coward, says his champion, my good brother Wooten. I do not believe that either of the Kellys are cowards, but it is painful to contemplate brave men, assailants, firing upon men who are not trying to return their fire. One of them down on the ground, wounded, and with his back to them, doing nothing except trying to escape under the canvas, out of their sight, but not out of danger. It does seem that brave men would have thought of the danger to the innocent spectators inside the canvas while they were emptying their pistols at the showman in the direction of the canvas. The evidence clearly demonstrates that David Oxford received his death wound just at the time the showmen were going under that canvas, and at the proper time I will also demonstrate to you that the ball which produced his death was sped upon its fatal errand by none other than John or Charles Kelly. Then, according to their theory, if the showmen commenced the assault, and it was necessary for the Kellys to return the fire, that necessity no longer existed. Their foes were retreating, and their own safety was already secured. But the gentlemen for the defense both say that in my opening argument I made a terrible onslaught on all the witnesses for the defense, and with a flourish of trumpets gave them to understand that I intended to devour poor Russell. Ah, what witness did I assail? Whose name did I mention? You will bear me out in the assertion that I called no name. Some of the defendant's witnesses, I said, I would give the charity of my silence, and leave to your minds the impressions produced upon them by the evidences detailed from the stand. That was about the sum and substance of what I said, except that their evidence was contradictory, while the evidence of the state's witnesses was entirely consistent and harmonious. I said further that there was one witness I intend to pick until there would be no meat left on the skeleton of his evidence. I was particular not to call any name. Then, had they not judged their own witness by singling him out from the cloud of witnesses? Did he not, like Satan, above the rest in shape and gesture proudly eminent, stand like a tower? As Nathan said unto David, till they not say unto Mr. Russell, Thou art the man. And yet, forsooth, I am asked, upon what meat doth this our Caesar feed, that he is come to be a destroyer of men, because they happen not to be upon his line of action? My brother Wooten commends to me more forbearance, does he? If Mr. Russell is destroyed, I can say to him truly, Shake not your gory locks at me. Thou canst not say I did it. Your own champions have judged you, and by so doing, gentlemen of the jury, they have thereby saved me much of my allotted task. My brother Wooten says, if the records of your court speak the truth, deceased was shot by Charles A. Kelly, who has already been convicted. I did not intend to allude to that fact, because not in evidence, but as it is admitted, I will notice that admission in passing. I did say, and I still say, that the evidence shows that John R. and Charles A. Kelly were moved by a common intent from the moment of time when he drew his pistol and fired his first shot until the curtain fell upon the bloody tragedy in which they were the chief and only actors. Although Charles A. Kelly has been convicted, in my opinion, he is more deserving of sympathy because less guilty than John. The evidence demonstrates that John first got into an altercation with the showman and first drew his pistol and fired the first 1, 2, 3 shots. Charles first appears upon the scene as a peacemaker. Clark meets him inside the show and shakes hands with him. He hears the noise at the door, occasioned by his brother, an angry dispute with the showman, and comes out. He takes hold of John to get him away, which is conclusive evidence to my mind that he saw and knew John was in the wrong. Why did he not continue to act as a peacemaker, and thus secure to himself the blessing promised to the peacemaker? If he had done so, we should not have been here this night. Bear in mind now the principle of law I read you in the opening of this case, where men went to rob a gentleman's park. They all united in an assault upon the gamekeeper. Their common design was to steal game. So far as that crime was concerned, they were all alike guilty. But one of them, after they had wounded and disabled the gamekeeper, without the cooperation of the rest, went back and robbed him. It was held that, so far as the robbery was concerned, he alone was guilty. It is the common design, the intent in the minds of all, to do a certain thing forbidden by law, that makes all the participants equally guilty. Well, after Charles saw that John was bent on murder, that nothing but blood would satisfy him, and that intent on the part of John was evidenced to Charles by external circumstances capable of proof, to wit, the firing of his pistol at, towards, and upon the showman, and Charles joined him and cooperated with him in that intent by doing the same thing by the use of a weapon likely to produce death in a manner calculated to produce death. I care not if the thought entered his brain but one single instant or moment of time previous to his firing of his first shot. There was a common intent in the breast of each, evidenced by the acts of each. Both were trying to kill, both without justification. Both did kill, for the act of one was, in law, the act of both. When all the circumstances of the killing in the language of our code showed an abandoned and malignant heart, and both are alike guilty, then the conviction of Charles upon the same bill of indictment ensures the conviction of John upon the same evidence. If it was murder in them to kill Ames, or voluntary manslaughter, in the heat of passion, and in the commission of an unlawful act, then it could not be misadventure to kill Oxford at the same time. And I want no authority in support of my position upon this point, better suited to my purpose than that used by Mr. Wooten against it, viz., Russell on Crimes, page 29, which applies in the language of the authority only to a case where the murder was committed in prosecution of some unlawful purpose, some common design, in which the combining parties were united. It does not matter whether they came to town on that day with murderous intent or not in the breast of each. If they had that intent in common, at the moment it is evidenced by shooting in concert at the showman, it is sufficient. The presumption of malice on their part is strong, because they came to the place armed and ready for any emergency. It is still stronger against them from the fact that they used their arms thus provided in a public place, where hundreds of persons, men, women, and children, were assembled, and reckless disregarded their presence and exposure. The law brands men who thus act as enemies of their race, with malice towards all and charity or love towards none. If he who carelessly throws a brick or stone from the scaffolding of a building in a public place kills a passerby without any intention to do so is a murderer. Of what lower grade of crime can one, who, like the prisoner at the bar, shoots into a crowd in a public place, intending to kill, be guilty of? My brother Wooten has brought a venerable book into court tonight, the best law book and the first law book ever written. I am glad he has brought it. I believe in it. One of the laws in that book, which I contend his client has violated, was promulgated by the Almighty amid the thunderings of Sinai. Thou shalt not kill. I think my brother has been unfortunate in his selections from that book, and in their application. His allusion to Cain may do, because Cain was the first murderer. He has read you from that book about the trial of Abraham's faith, and the offering of Isaac by the command of the Almighty, and compares the aged father of John Kelly to that venerable patriarch, in that he has come up here, court after court, to offer up his son by command of the law. Unfortunate comparison. Under the facts of this case, there is another father and son whose history is given in that book, much more appropriate in its application to these facts. David and Absalom. Isaac was a good boy and had never transgressed God's law, nor wrung his father's heart with anguish. He was as pure and spotless as the innocent lamb, and hence an acceptable offering for sin. From him and his seed all the world was to be blessed, in the babe to be born in Bethlehem. Absalom, on the contrary, was a bad boy. He slew, or caused it to be slain, his brother. He made war against his own father and took his kingdom from him. He wrung David's heart with untold anguish. Notwithstanding all, David still loved him. The paternal heart still yearned over his erring, wicked son, And when he heard that Absalom was slain, he exclaimed, "Oh, my son Absalom, my son, would God I had died for thee." And such I apprehend is the feeling of old Mr. Kelly, though his boy has erred and wrung his heart, and brought sorrow upon his declining years. He still, like David, loves him. Oh, how strong, how enduring is a parent's love for their offspring. But according to my brother's theory, this aged father will find a substitute for his innocent boy, so unjustly persecuted in the person of the man whom Russell saw standing inside of the canvas near the door. Don't you know that the man with the black mustache and the broad face, soft hat with the wide brim, sort of mixed coat with the collar turned down, with a Colt's 5-inch in his hand, was an afterthought of Russell's, fixed up to fit this case, and to acquit the Kellys? If not, I ask, why was not that man arrested? Did he not stay in the place all day after Oxford was killed? Ah, gentlemen of the jury, that subterfuge won't do. You know, and I know, and the honorable gentleman himself knows, that if it had been a fact that that doorkeeper had killed David Oxford, he never would have gotten away from this place alive. If the blood of poor Oxford cries for vengeance, not against the prisoner, but against the showman, I ask the gentleman why he has not been brought forward and tendered as a substitute. You know that if the showman was guilty and had escaped, they would find him if he was on the top of this green earth. End of section 92. Section 93 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John R. Kelly for the murder of David W. Oxford. Dawson, Georgia, 1871, Part 9. I say also with the eloquent advocate, the state of Georgia does not want the blood of an innocent victim to smoke upon her altars. She does not want the showman punished for a crime he never committed. Nay, more, she does not want the blood of any to smoke upon her altars. Our good old mother, the state, would prefer that all her children should obey her laws and live together as the children of a happy household, in peace and love. She sets her laws before us and kindly but firmly tells us we must obey them. If we set up our will and our own law in opposition to hers, and thus incur the penalty of disobedience, we must meet the consequences. She said to John R. and Charles Kelly on the 2nd day of November last, "You must not go to that show ground with arms on your persons." She said to them further, "You must not engage in an affray." She said to them further, "You must not kill any of my children. If you do, I will punish you." She intends these laws for our good. The best interests of society are involved in an implicit obedience to them, and all other laws for the preservation of peace and the safety of the citizen. In violation of law, they were here on that day. But, says the gentleman, were they not invited here by the showman? If invited, were they not here lawfully? They were not invited to come and bring pistols, deadly weapons with them, nor to come prepared to use them with much deadly effect. The showman had no right to invite anyone to violate a law of the state. When the state imposed a tax upon shows, she thereby recognized them as lawful, and she promised to throw around them, while on her soil, the mantle of her protection. For, gentlemen, however much private citizens may disagree as to the propriety of attending such exhibitions, all states and statesmen encourage amusements for the people, and some states provide them at the public expense, upon the principle that all work and no play makes Jack a dull boy. By the payment of the tax imposed by law, as I have before said, Ames Circus was lawfully here on the 2nd day of November last. By carrying pistols on their persons on that day, John R. and Charles A. Kelly were here in open violation and in defiance of law. In other words, they were unlawfully here. But time admonishes me to hasten on. I cannot stop to answer all the arguments of both the learned gentlemen for the defense. With the most of their authorities I agree. We only differ as to the application to the case at bar. My brother Wooten reads and comments at length upon the case of Keener v. State, 18 Georgia 194. Why, gentlemen of the jury, there is no analogy between that case and this. Reese went to the house where Keener was, his castle, for the time being, breathing out threatenings and slaughter against Keener. Counsel read you how he went to the door and kicked upon it, and called to those within, "Bring out your damned Keener." He raised a stick over a woman's head and told her, if she did not bring out her man Keener, he would kill her. He had threatened Keener's life, and those threats had been communicated to Keener. Reese was a desperate man, and Keener had enough to excite the fears of a reasonable man. Reese undoubtedly intended to commit a felony upon the person of Keener, or at least Keener had good cause to so believe, and hence the reason for the Supreme Court's reversal of the judgment of the court below in that case. The case of Monroe v. State is in the same category. There are some men on this jury who lived in Lee County at the time and know all about the facts of that case. Dr. Reagan, I know, recollects it. Monroe was one of the most peaceable of men. Macon, on the contrary, had the reputation of being one of the most desperate of men. Dr. Monroe was a member of the inferior court to the county, and as such had in his official capacity ordered suit to be brought upon a bond, which Macon had given as county treasurer, and thus being a leading member of the court, he had incurred the enmity of Macon. Macon had threatened his life, and those threats had been communicated to Monroe. Not only he, but everyone else who knew the desperate character of the man, believed he would, if opportunity were given, execute those threats. Well, Monroe endured, and hid and skulked, until life became a burden, and until the dread alternative was impressed upon his mind, and convinced his judgment that he must either kill Macon or surrender up his own life. You know how he killed him. He shot him from an ambush, but when he shot, Macon was hunting for him, with his rifle on his shoulder and the trigger sprung. Macon was a good shot, and as quick as the lightning's flash, and hence Monroe had good reason to believe that his life depended upon his shooting Macon in the way he did. He had sufficient cause, in the language of all the authorities, to excite the fears of a reasonable man. If he did not, in fact, have, there was, at least, cause enough to raise a doubt, and he was entitled to the benefit of that doubt. Counsel for defense have stated the rule correctly as to circumstantial evidence. I do not think, however, that this case depends upon circumstantial evidence. I think I shall be able to demonstrate to you that the evidence establishing the guilt of the accused is of the most direct and positive kind. I agree with them also that if there be a reasonable doubt upon your minds as to the guilt of the prisoner, it is your duty to acquit him. But bear in mind that the doubt which would justify you in acquitting him must be a reasonable one, not a capricious, uncertain doubt, having no foundation in truth. It must not be the creature of your own imagination, conjured up by your own brain, for the purpose of giving you a pretext to acquit. The doubt must be raised in your minds by a lack of evidence sufficient to produce conviction, either as to the commission of the crime itself, or as to the identity of the person committing it. You must be satisfied from the evidence, beyond a reasonable doubt, that either John R. or Charles A. Kelly produced the death of David Oxford in manner and form as laid in the indictment, or you cannot convict the prisoner. But, gentlemen, the lateness of the hour reminds me that I must hasten to a conclusion. I have endeavored to answer some of the arguments advanced by the judgment for the defense. I cannot, without wearying your patience, advert to them all, as I hope I have shown you that those most plausible are utterly wanting in merit. sufficient to support the plea of innocence when we apply the test of facts and the law as applicable to this case. Having given you the law in the opening of the case, I shall not advert to it again. I simply ask you to keep the legal principles I there laid down firmly fixed in your minds, so that you may apply them to the evidence as we proceed to examine it, which I shall now do as briefly as possible. The first witness sworn for the state was David Young. But before we commence our comments upon the testimony of any of these witnesses, I want you to get firmly fixed in your minds their various positions, and see what favorable positions they severally occupied for seeing all that transpired on that occasion. I want you also to remember the kind of witnesses introduced by the state, all of them, save one, of mature years, and all the adults except one lady were men, who from their very appearance, if personally unknown to you, you would at a glance say were cool, calm, and collected at the time, and saw just what they swore to, and nothing more nor less. Now, gentlemen, we have Mr. Young here on this rail, inside of the old circus ring, between the ticket wagon and the door of the sideshow, and in full view of that door or gangway, as it is sometimes called. A good position for observation, anyone would say. As the difficulty progresses, and his curiosity is excited, he advances a few steps and takes position on the elevated ring of the old circus, still nearer the door, still nearer the parties engaged, and consequently in a still better position to see what was going on. Then his third and last standing position, as indicated at a point east from the ring of the old circus, still in full view of the parties, and also in view of the piazza of his own house, standing as it does almost due south from this little canvas. Now, if anyone else fired either one of the first three shots, which Young testifies about, you know he would have seen it, he would have known it, and he would have exonerated John R. Kelly from the charge of being the assailant. Well, he swears positively to the first three shots being fired by him. Did not see anyone else fire. Did not hear anyone else fire. Heard no other pistol fire except that in the hand of Mr. John Kelly. I want you to fix that fact in your minds firmly, and keep it there as we go along. Just as the third shot is fired, Young sees his wife beckoning to him from the piazza of his house, and starts home. He does not see any more shooting, but he sees and does something else, which we shall come to presently. It seems that a kind Providence so arranged these witnesses to this bloody tragedy that some one of them should be in position to see what another could not see, and thus we have two more who saw every shot after the first one, and three who saw all fire that were fired after the third, and the persons by whom they were fired at the same time. James Clark was inside of the sideshow, met Charles Kelly in there and shook hands with him. Loud talking, angry words commenced at the door, indicating a breach of the peace. Charles recognized the voice of his brother and went back by the way he came in, through the door towards the difficulty. The loud talking, the angry words increased to such an extent that Clark did not think it safe to go out at the door, and, prudent man as he was, he raised the canvas at the back part to the right of the big ox and went out. After he got out, he turned to his left and passed around the south side of the little canvas. Just as he got about opposite the east side of the little canvas, he heard the first shot. Did not see it, nor know who fired it. He saw the mules and wagon across the ditch, and started for the wagon to get behind it. Two other shots were fired, and last ball passing between him and the mules before he reached them. Passing around the head of the mules, he took position here, pointing out to the jury Clark's position as indicated on the diagram, in full view of the whole scene. What then did he see? What sight did Clark behold from this point of observation? The showman firing at the Kellys or at anyone else? No, he saw two men coming around this fly, pointing it out, one down on his left elbow and hip, trying to help himself along. Alas, Poor unfortunate Ames, the other holding him by the right arm. What next? Then John and Charles Kelly coming around from the same direction, pursuing, not being pursued, each having a pistol in their hands and firing in the direction of the men who were making their way off. They continued to fire until the men disappeared under the canvas. They were firing in the direction of the canvas, and they ceased firing about the time the men disappeared. Saw no one else fire. Heard no other shots fired. 3 shots had been fired before he got behind the wagon, and he estimates the entire number that he saw and heard at from 7 to 10 shots. The next thing he heard was that there was a man killed. He went around to the spot and found the man. Alas, poor Oxford, lying on his face dead. You know, gentlemen, that if anyone else had fired a shot after Clark to position behind that wagon, he would have seen it. Milton Gamache, we will take up next. His position was also a good one, also a different standpoint from either of the others, a little east of north on this diagram, from the door of the little show. He heard 1 shot, which he did not see, but Young did see who fired that. He then turned around and saw all the balance. Who fired these shots, Mr. Gamache? John and Charles Kelly is the answer. They were the only persons he saw fire. They were firing in the direction of the tent of 3 men, who seemed to be getting away, and eventually went under the canvas. He saw them go under the canvas just to the left of the door from where the Kellys were shooting at them. Any concert of action, showing a light malicious intent to the 2 Kellys in all this? William V. Oxford was standing on the old circus ring, an elevation of about 12 inches above the surrounding earth, just to the right of the ticket wagon, a little west of north from the door of the sideshow. Another good point of observation. There could not have been selected a better one. He heard fuss at the door, saw John Kelly, the aggressor, and Charles, seemingly a peacemaker, apparently trying to prevent a difficulty, until John had fired his 3rd shot. Then Charles joined him in his murderous attempt, drew his pistol and commenced firing also. And from that instant of time, gentlemen, there was a union or joint operation of act and intention on the part of both the brothers. After the 3rd shot, according to this witness also, the showman commenced giving back and trying to get away. You will observe from this diagram that they disappeared from the view of this witness when they passed around this fly on which the big ox was painted. And so he says, pointing out the jury the position of Oxford. Now, not to dwell longer on his testimony, as I must hasten on, you will observe the perfect corroboration between him and all the others, and further, that the 2 Kellys were shooting as fast as they could. Now you know that 2 men, each with loaded repeaters, intent on killing others, when they try to do so, can shoot very fast. Those 2 pistols must have been emptied in a very few seconds of time, and before Young got 10 steps from the spot in the direction of his home. James Miller, Reuben Guise, and Tim Sullivan, all men of coolness and courage, as evidenced by their appearance upon the stand, and all occupying different standpoints, saw no one else fire a pistol on that day, except John and Charles Kelly. If anyone else had fired out or towards the Kellys, they were in the line of fire. They were, as all men in their positions would have been, anxious for their own safety. Mr. Sullivan turned and walked off, but the other 2 did not. They stood their ground, maintained their positions, and they saw no one else fire. Don't you know they would have seen the showman fire if they had done so? Mrs. Mary J. Halsey was on the ground, standing near the door of the sideshow, had 8 children under her charge, was waiting for her brother-in-law to return with the tickets which he had gone to purchase, when the shooting commenced. Did not know the men who were shooting, but says they were shooting towards the canvas. As the other witnesses who knew the Kellys all swear that they were shooting towards the canvas. Then, the men whom Mrs. Halsey saw shooting towards the canvas were the same persons. By this witness, We also proved the presence of women and children upon the ground at the time, their close proximity to this affray, and the terror it excited among them. As soon as pistols commenced firing, she took her little charge and left the ground, panic-stricken, as did hundreds of others, and sought the protection which Mr. Hooks Brown's house afforded. The scene may be better imagined than described. Women and children running in every direction to save their persons from the deadly effects of murderous pistol balls, fired indiscriminately into a crowd, at a public place and without regard to consequences. Is there not conclusive evidence of an affray in a public place, to the terror of the citizens and disturbance of the public tranquillity? In this case, and that this prisoner and his brother were sole actors and participants in that affray. The counsel for the defense say that James B. Avant, the first witness examined by them, proves that the first pistol was fired by someone else. I deny it, and appeal to his testimony to support me. He was standing on the wheel of the ticket wagon, with his left side to the door of the sideshow. He was intent upon the object which took him to the ticket wagon, viz., the purchase of tickets for some ladies. He heard the noise, but did not look that way until the first shot was fired. He did not see who fired that first shot, but bear in mind that David Young did, that William B. Oxford did. That shot was fired by John R. Kelly. Avant says the second shot came from the pistol of John R. Kelly, but the third shot, judging from the smoke, was fired by someone else. It looked to him like Mr. Charles Kelly had fended off the pistol in the hand of someone else, as the smoke arose about the hand of Charles Kelly. This was mere supposition on the part of Avant, while we had the positive evidence of two other witnesses that the third shot was fired by the prisoner, and by no one else. Then how does Avant contradict the state's witnesses? Which had the best opportunity to see who was doing the shooting all the time it was going on? Positive testimony outweighs negative, and consequently the evidence of the state's witnesses is not shaken by Avant's. But Avant saw something else the state's witnesses did not see. He was positive about one thing, and that is, as to the bullet holes through the canvas and in the monkey wagon. Mark the position of this monkey wagon inside that canvas, the position of the albino woman, the big ox, and the place where Clark's first and Oxford next went out, showing them the diagram. Did not these balls rain like leaden hail on that canvas, threw it into the monkey wagon, into the mother of the albinos, and into poor Oxford? The showman did not fire them, because they were next to the canvas. The Kellys were outside of the showman, firing at the showman, and firing towards the canvas. Then, if the Kellys did not fire the balls that went through the canvas, into the monkey wagon, into the mother of the albinos, and through the body of Oxford, who did? End of section 93. Section 94 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John R. Kelly for the murder of David W. Oxford, Dawson, Georgia, 1871, Part 10. Having thus glanced at the testimony of Avant, merely for the purpose of demonstrating that it does not contradict the state's witnesses as to the identity of the person who fired the first three shots, as well as to demonstrate that the shots fired by the Kellys went through the canvas and into the monkey wagon, I wish you to weigh and consider this latter fact in connection with the evidence of another one of the state's witnesses, viz., George Young, the little boy, testified before you with all the composure to be expected of a witness much older than himself. He told just what he knew and no more. He knew little and knew that little well. He saw David Oxford when he came out of the sideshow with his child in his arms. He says that Oxford lifted up the canvas on the backside next to the big circus and came out half bent, that he ran in the direction of his father's house until he fell, with his child still in his arms, that he saw his father, David Young, when he went to where deceased was lying, take the little child out from his embrace and hand it over the fence into his own yard. That was all he knew, except that he saw the two albinos come out of the sideshow at the same place Oxford came out at, and immediately after he did. And bear in mind, gentlemen of the jury, George Young saw no one else come out with Oxford. Now Dr. Price testifies that deceased must have been in a stooping position when he received his death wound, from the fact that the ball came out about 4 inches higher up the body than where it entered it, and that he could not have kept on his feet more than 1 minute after the wound was inflicted, that he, witness, was inside the big circus on a seat near the top, had his little son with him, heard 3 balls strike that big canvas near where he was, sat perfectly still until the firing ceased, does not think there was exceeding 10 shots fired. After the firing was over about 1 minute, he looked out between the top and side canvas and saw deceased lying with his child in his arms, started out to go to him, and when he got outside, he found that Young had taken the child away. Now, gentlemen, let me call your attention once more to this diagram. Look at the position occupied by Dr. Price inside the circus, as he indicated by him, pointing out the spot to the jury, and you see that he was in exact range with the Kellys, in firing in the direction of the little tent. Such balls as missed the monkey wagon, the albino woman, and David Oxford, passed entirely through the little canvas and struck the big circus canvas beyond. And now let us recur once again to the evidence of David Young, and take it up just where we left him to bring in the evidence of James Clark. Young saw 3 shots fired by John R. Kelly. Just as the last shot was fired, he saw his wife signal from his piazza. Like all wives, she was anxious for her husband's safety and wanted him to come away. He started to his house, and when he had gotten about 20 steps, his attention was called to the little child in the arms of a man lying on the ground about 30 or 35 feet south of the little canvas. Don't you know from the testimony of the other witnesses that the fire had ceased before Young had gone 10 steps in the direction of his home? Don't you know also that if the men had been still shooting in the direction of the little canvas, it would have been dangerous for Young to have gone to where Oxford was lying? As soon as Young's attention was called to the little child, he turned aside to the right and went to where deceased was lying, took the little child, all bloody, out of its father's arm, carried it to his yard fence, and handed it over to someone who was there to receive it. When he handed the child over the fence, Mr. and Mrs. Russell were inside of David Young's yard. Bear that fact in your minds also. We have thus examined Young, Clark, William B. Oxford, Gamage, Miller, Guys, and Tim Sullivan, all of whom saw the shooting, and no one saw anyone else shoot except John and Charles Kelly. Then, according to this array of testimony, no one else could have killed David Oxford. It must have been one or the other of these men. To break the force of this testimony, they have introduced several witnesses whom I shall not refer to by name. As I said in the opening, I shall give them the charity of silence, and leave to your minds the impressions made upon them by their evidence as detailed from the stand. I am sorry for them. They ought not to have been brought here, but they rely mainly upon William R. Russell, the man whom, according to my brother Wooten, I threatened to destroy. I am not in a humor to cut him up into chicken meat, as the gentleman would have it, but I don't think his evidence is entitled to any weight whatever with you, as I think I have already sufficiently shown, and I shall now proceed to give you my reasons still further for that belief. I appreciate the motive of Mr. Russell in trying to extricate his friends from the awful situation into which his own improper, wicked, and reckless act has placed them, while I condemn the means which he employs for that purpose. But for Russell's difficulty with the doorkeeper, there would have been no bloodshed here on that day. The Kellys undoubtedly took up his quarrel and sought to avenge what they understood to be an insult offered to him. He ran away and they did his fighting for him. Perhaps Russell intended simply a little bluster and bravado, sound and fury signifying nothing. They intended something more. Well, in order to acquit the prisoner, Mr. Russell places himself inside the sideshow, along with David Oxford. After the row commences outside the door, thinking, discretion is the better part of valor. He starts to go out at the back side. As they go under the canvas, and while he is stooping down, with the canvas resting on his right shoulder, he facing south at the time, passing his wife and children out with his left hand, and while the firing is going on rapidly outside the door, in the hurry and excitement of such a moment, he sees a man with a black mustache, with a broad-brimmed, low-crowned soft hat on, with a sort of mixed coat on, and with the Colt's 5-inch repeater in his hand, with the muzzle pointing down as though he had just fired it, with smoke between himself and the man. Wonderful! Astonishing exhibition of clear-sightedness on the part of this wonderful witness. He not only saw the man, the color of his mustache, measured the width of the brim and the height of the crown of his hat, and the color of his coat, but actually measured his pistol, and could readily tell that it was a Colt's 5-inch, and all in a few seconds of time, according to his own testimony. He saw all this across a 30-foot canvas, while he was down in a stooping position, with the canvas on his shoulder engaged in passing out his wife and children, and in a space of time that would have been consumed in walking across this courtroom, not more than 30 feet. And while he was seeing this, according to his testimony, Miss Mattie Reynolds, one of the defendant's other witnesses, sworn next after him, says he was outside, that he ran up and fired 2 shots and then ran off. His memory is good, but not reliable as to his own pistol, which you will remember Miller and Solomon both swear he drew upon the doorkeeper, and which Solomon says he fired once in the melee outside the door. And yet, both himself and his wife swear he did not draw a pistol on that day. You will also remember the testimony of Mr. Peoples, one of the jurors who tried Charles Kelly, and who heard Russell's testimony on that trial. He says that Russell then swore that he was facing west, while under the canvas, with the canvas resting on his left shoulder, and that he passed his wife and children out with his right hand. Strange, passing strange, that his memory should be so good about some things, and so utterly wanting in others of equal importance. He forgot that he had or drew a pistol himself, forgot that he fired a pistol himself on that bloody day, and although it has been but little over 2 months since he testified from the stand before, he has also forgotten that he then told the jury his left shoulder held up the canvas, that he faced west, that he passed out his wife and children with his right hand. He now reverses the whole thing and tells it altogether different. Is such a witness worthy of belief? But, says my brother Wooten, the mind looks out for a motive to action in this case, and he endeavored to show you that it was reasonable to suppose the showman did this thing, because he had a difficulty with Russell at the door, and wanted satisfaction. I fail to see it in that light. At the instant of time, according to Russell, while this bloodthirsty showman was thus standing calmly within the tent, bent on shooting 2 unarmed men who were escaping from the tent, one of them with a little child in his arms, and the other with a wife and 3 children in his company. His friends were being murdered just outside of that tent, within a few feet of where he stood, and the 2 Kellys were riddling the canvas just behind him with balls from their pistols. If a showman or anyone else had stood where Russell placed him, 1 or more balls would have passed through his body. He was not there, gentlemen. If the showman had been intent on shooting anyone, he would have been outside assisting his own people, not inside, where he was in more danger to himself, shooting at unarmed men. Neither was Mr. Russell inside that tent. He did not, as he says he did, go out with David Oxford. If he had done so, George Young would have seen him, and if he had been inside when the fuss commenced, James Clark would have seen him. Again, gentlemen, take Russell's account of his parting from David Oxford after they got outside of the little canvas, and how heartless, how wanting in all the instincts of humanity does he make himself appear. He saw the blood gush from his mouth with such force as to stain the dress of his wife, as to spot the dress of his child, as to redden the beard of the poor death-stricken man. He heard him, in the agony at that moment, exclaim, "Lord, have mercy," and then took his wife and children and went away from him, as though he had been a wild beast, instead of that wife's brother. No offer to aid him, no hand extended to break the force of his fall upon the ground, no thought of care for the poor little child already orphaned and covered with its parents' blood. No call for a doctor to save him, or make an effort to do so, nor does he again even inquire for him or try to learn what has become of him, or go even to shed a tear over his corpse, until others, and perhaps strangers' hands had borne him from thence to the drugstore of Dr. Cheetham. I do not believe that even Russell could have been so utterly callous and cold as to have acted in such a way, and to cap the climax of his own infamy, instead of raising the hue and cry against the man with the black mustache, with the broad-brimmed soft hat, the sort of mixed coat, and the Colt's ever to be remembered 5-inch, who killed David W. Oxford while he was passing out of that tent in company with him, instead of searching through the whole circus company, into every wagon box or other hiding place, until he found him and had him committed to prison to answer for that atrocious crime. He does what? Goes off in search of his little boy, and Young tells you he saw that doorkeeper, that terrible man, that cold-hearted, diabolical murderer, according to Russell, here in this courthouse next day. Why was he not then arrested? Just because he was innocent, just because Russell had not then had sufficient time to concoct his base fabrication. Away then with such a witness. He is utterly unworthy of belief. I commend to his defenders another passage from that venerable book, brought into court tonight. Lying lips are an abomination to the Lord, but they that deal truly are his delight. He that speaketh truth sheweth forth righteousness, but a false witness deceit. The mind, in looking out for a motive to action, utterly fails to find any motive, or any incentive that could have prompted Ames, or any of his men, to have insulted anyone in such a gross manner as is charged against them on that day. He, as proprietor, had invested an immense sum of money in that venture. His object was to make money, and in order to realize this expectation, he had to be popular with the people, as well as making his exhibitions attractive, so as to draw crowds to witness the performances. He was a popular man, and for one pursuing his calling, a very gentlemanly, quiet, and unobtrusive personage. He would not have kept in his train a single person who would have insulted anyone, much less a woman, if for no other reason, because it would have been a bad policy to have done so. His success and profits depended upon popularity and attractiveness. An insult offered to a lady in Dawson, though unavenged by her friends, would have followed him wherever he went, and would have told against him by keeping other ladies away from his exhibitions. Again, his popularity depended upon the prompt suppression of all rowdyism on his grounds about a show. If he permitted a Russell and his backers to run off his doorkeeper in Dawson and endanger the lives of women and children in Dawson, men of similar dispositions might do the same thing elsewhere, and soon he would have had no spectators, and for the want of them his enterprise would not have been productive of profit. All Ames or his men tried to do on that day was to preserve the peace. In the interest of peace and good order, he yielded up his life. No one heard any call for gunmen on that day, save one of the defendant's witnesses, and if there were any such persons on the ground, they certainly did not use their guns against this prisoner and his brother, as they might justly and lawfully have done. But, gentlemen, exhausted nature cries for rest. The lateness of the hour admonishes me that it is time to close this argument. I have endeavored to discharge my duty, and although it may have been done in a feeble way, yet I feel I have done so to the best of my ability. My skirts are clear, whatever may be the result, and as I retire from your view, one more scene in this drama will have closed. Soon the responsibility will rest on you alone, and may the great Father of us all guide you by his wisdom in coming to a just and righteous verdict, one that will meet the approval of those who are to come after us, when you and I, together with the passions and prejudices of this hour, shall have passed away. The charge of the court. Judge Harrell. Gentlemen of the jury, it is scarcely necessary for me to remind you of the importance of the case now about to pass into your hands for your exclusive action. The patient and attentive manner in which you have interested yourselves in the investigation since it was submitted to you shows that you fully appreciate not only its importance, but the magnitude of your responsibilities in connection with it. As jurors, you stand as the representatives of society to declare whether the laws made for its protection and security have been violated. On the one side is the good order, peace and dignity of the state, the majesty and dignity of the laws and the protection of every citizen. On the other is the life or death, liberty or imprisonment of the prisoner at the bar. The issue is formed upon this bill of indictment. The state v. John R. Kelly, who is charged with the crime of murder, and the oath which you have taken informs you that the issue is to be well and truly tried, and a true verdict given according to the evidence, without prejudice, without favor, with minds perfectly impartial between the state and the accused. Public opinion, popular feelings, individual prejudices for or against the prisoner have nothing to do with the case. As far as your duties are concerned, it is a matter for the judgment to determine, influenced solely by the law and the evidence as submitted to you from the stand, and whatever the facts proven and the law applicable to the case demands, should be honestly, conscientiously, and fearlessly pronounced. For consequences you are not responsible. Your duties cease with your verdict, and if those duties are properly performed, there your responsibilities end also. You speak, not your private opinions as citizens, upon a matter in which you are at liberty to exercise a choice or use a discretion, but as representatives of the law, sworn to execute its behests. You pronounce the judgment of the law. If the prisoner at the bar has violated the law, he should receive the punishment affixed to such violation. If he is innocent, he should go forth from the temple of justice with his innocence vindicated by your verdict. And in determining this question, you cannot go outside of law. You cannot be influenced by any considerations outside of the evidence. If you should do so, your verdict would not speak the truth according to law, and whether it was one of guilty or not guilty, you would be equally culpable. To err on the one side is as criminal as to err on the other. Fortunately for us, as far as the law is concerned, there's been so many adjudications of the principles controlling cases of this kind that there is little room for error or mistake. And those adjudications cover not only the general principles that govern the case itself, but they guide the jury in their investigations and point out the manner in which they arrive at a conclusion or true verdict. The rules of law prescribing your powers in criminal cases, the mode of construing evidence, the degree of credit to be accorded to individual witnesses, and the sufficiency of evidence necessary to authorize you to come to a conclusion are plainly laid down, and as well defined as the law of the crime itself. And it is a matter of congratulation to me that in giving to you in charge the law of this case, I am able to do so upon nearly all of the principles involved, in the words of judges who have honored the bench by their legal attainments and personal integrity, and which have received the endorsement of our Supreme Court. And first, as to your powers. In criminal cases, you are made the judges of the law as well as of the facts. But this power does not loose you from all restraint and turn you over to the exercise of an unbridled discretion or arbitrary judgment. It does not authorize you to declare law to be not law, or something which is not law to be the law, or that it should be different from what it is, or that it is a hard law and ought not to be executed. Your powers have been so well defined in this respect by the Supreme Court that I will read it to you from the case of Brown v. the State, so that there cannot be a mistake on this question. Nor does it mean, speaking of the powers of the jury to judge of the law, that jurors may do as they please or disregard the law as given them in charge by the court. If the court errs in its rules or charges the parties, may accept and have its errors corrected. If the jury should disregard or set aside the charge of the court, their errors will be irreparable, and the rights of the parties jeoparded or even destroyed. For as no power is given to juries to declare the law, no tribunal has been established to correct their errors of law. And further, the section of the Code declaring jurors to be judges of the law, as well as of the facts, furnishes the meaning of these words, by saying they shall in every case find a general verdict of guilty or not guilty. To do this, it is absolutely necessary for them to come to a conclusion dependent upon both law and the facts. They must say to themselves the facts are so and so, and the law is so and so, and the accused is therefore guilty or not guilty. But it does not follow from this that the jury may make up their judgment of either the facts or law from any other than the legal sources of information. Where do you get the facts? Have you any right to imagine them? Must you not look to the evidence for them? Suppose a judge was to charge the jury that they were not bound to find according to the evidence, that if they had a notion about the case not derived from the evidence, they might reject the evidence and find upon that notion. Would not such a charge be in the very teeth of that oath, which binds them to find according to the evidence? They must, it is true, judge of the facts. They must determine whether or no, under the evidence, the prisoner is guilty or not guilty, but they must take the evidence as it comes before them, through the proper legal channels, and nothing is evidence that does not come in that way. So also of the law. To find a general verdict of guilty or not guilty, they must come to a conclusion as to what is the law of the case. They must apply their conclusions as to the law, and their conclusions as to the facts together, and they must, from their judgment of both the law and the facts, find a verdict. But how are they to get at a knowledge of the law? This court has said that they cannot even carry the criminal code to their room. They are generally plain men, unskilled in the law. Is it possible that our lawgivers intended to leave so grave a thing as the law of crimes to the consciences and good sense and internal suggestions of a jury? We think not. The law appoints a channel by which its rules and regulations get to the jury. It is made the duty of the judge to convey it to them. In the case of Keene v. State, 18 Georgia 230231, Judge Lumpkin said, "It is the duty of the judge to declare to the jury what the law is, with its exceptions and qualifications, and then to state hypothetically to the jury that if certain facts which constitute the crime are proven to their satisfaction, they will find the prisoner guilty. Otherwise, they will find him not guilty. It is made the duty of the judge to tell them the whole law of the case, He may read it to them, or give it to them in his own words, or he may assent to, or dissent from, legal propositions advanced by counsel upon one side or the other. He is the channel through which, under the law, the jury get the law of the case before them. When a jury are impaneled, they are presumed to know nothing of the case. The pleadings, the evidence, and the charge of the court put it before them, and in forming their judgment upon the law and the facts, they are just as much at liberty to pay no heed to the evidence as they are to pay no heed to the charge of the court. The latter is the channel through which they get the law. The former is the channel by which they get the facts, and they have as little right to take up their internal suggestions of the one as they do of the other. It is unfair and unjust to cast upon juries any such duty as is claimed for them. What conscientious man would undertake under his oath to say what was the law of a case, if you deny him access to the law books and tell him that the judge is not a sure guide? If you command him to judge and shut him up from the means of judging, you do as the Eastern king did with his soothsayers. You command him not only to tell the meaning of the dream, but what the dream was. This a Daniel, and a Daniel alone, was equal to, but no man unlearned in the law of these days, however acute, with a full consciousness of the task he had undertaken, would, as we think, be willing, under his oath, to march up to it. And our experience is that our purest and most intelligent jurymen never attempt it. Lawyers and judges may tell them such is their right and their duty, but they nevertheless take the judge as their oracle and feel, and we think rightly, that they have satisfied their oaths when they take the law from the court without question. That class of jurymen who find verdicts upon their own notions of the law are generally the same class who act upon their own notions of the facts, and care as little for what the evidence teaches as they do for the law. From this you will see, declared by the law itself, the extent of your powers in judging of the law. End of section 94. Section 95 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John R. Kelly for the murder of David W. Oxford, Dawson, Georgia, 1871, Part 11. Next, as to your powers and duties in relation to the evidence. In construing the evidence, it is the duty of the jury, when an apparent discrepancy exists between the testimony of different witnesses, to reconcile the whole together, if it can be done, so as not to impute perjury to either. If from contradictory statements of a witness, or from conflicting statements of different witnesses, this cannot be done, then you must make your judgment from the weight of evidence, and the weight of evidence itself is determined by legal rules applicable to each case. You cannot arbitrarily discard the testimony of a witness. You cannot, from your private knowledge of the standing and character of a witness, or from circumstances in your knowledge acquired outside of the case, attach more or less credit to one than another. This would be relieving yourselves from the rules of law and following your own internal suggestions or discretion. In cases where there is no reason for you to believe that a witness is willfully false, you must look to the circumstances and proof, concerning which there is no doubt, the reasonableness of his testimony, his means of knowledge of the facts whereof he testifies, his interest, if any, in testifying, his intelligence and capacity and manner of testifying, and determine the value of his testimony in connection with that of others. In cases where the conflict of testimony is of such character as to produce on the minds of the jury a reasonable opinion that a witness has sworn falsely, or his credibility is attacked, you must look to the evidence introduced or used for the purpose of attacking his credibility, and from that evidence, taken in connection with the circumstances above mentioned, determine the degree of credit you will attach to his statements. A witness may be impeached in 3 methods. First, by disproving the facts testified to by him. Second, by proof of contradictory statements previously made by him as to matters relevant to his testimony and to the case. Third, by evidence as to his general bad character. Until the testimony of witnesses are affected, as in the first instance, or their credibility is attacked in one of these ways, all stand before you equally credible, and one is to be believed as much as another, and every fact testified to by them is to be taken as true. The law is explicit. Witnesses must be believed, unless they be impeached in some of the modes which the law declares sufficient to throw suspicion on their testimony. If their evidence be in no manner impeached, it is entitled to implicit belief, and the jury which disregards it incurs the guilt of willful or reckless error. Then, as to the sufficiency of evidence, the law declares that, in legal investigation, moral and reasonable certainty is all that can be required. In criminal cases, a greater strength of mental conviction is necessary to justify a verdict of guilty. It does not require the precision of mathematical demonstration. It does require moral certainty, and also that before a verdict of guilty can be rendered in any criminal case, the guilt of the accused should be established beyond a reasonable doubt. After a due consideration of all the evidence, construed according to the rules of law, if a reasonable doubt should remain on the minds of the jury, there is no question as to its effect. When the minds of the jury cannot come to a satisfactory conclusion on the issue before them, from the evidence properly considered, they should leave the parties as they find them, is the rule in both civil and criminal cases. But a greater degree of caution should be observed in coming to a conclusion when life or liberty are involved in the issue. A reasonable doubt arises from the absence of that amount and quality of evidence which ought to satisfy the impartial and unprejudiced judgment of a reasonable and conscientious man of the guilt of the accused, and would render it improper to convict. Doubt ceases where there is mental conviction. There can be no mental conviction where there is doubt. But a man may be satisfied that where there is an equipoise in his mind, after putting in the balance all of the circumstances pro and con, a particular plan or project, or in other words, when there is a doubt, it would be wrong for him to act. It is no more than the abstract proposition that a man's judgment ought to be convinced before he acts. It is not the doubt that satisfies, but the insufficiency of the evidence in some of the respects in which it may be proper to consider it, that leaves the mind in such doubt as to render it improper to act upon it. If the mind is wavering, unsettled, cannot be satisfied from the evidence whether the crime was committed at all, it would be improper to convict. But the jury ought never to be left to infer or conjecture that they can create a doubt for themselves and act upon it for the exculpation of the guilty. 1,000 fancies may suggest themselves to skeptical minds to create unsubstantial doubt, as that witnesses may not remember accurately, may be mistaken, may swear falsely, etc. Such things are not allowable. Witnesses must be believed unless they are impeached in some of the modes which the law declares sufficient to throw suspicion on their testimony. If their evidence be in no manner impeached, it is entitled to implicit belief, and the jury which disregards it incurs the guilt of willful or reckless error. Under these rules for your guidance, determine from the evidence whether the prisoner is guilty of the crime with which he stands charged, or one of less grade, or whether he is not guilty, and to enable you to come to a legal conclusion The court will read to you the law of the crime itself as it is plainly and distinctly prescribed in our penal code. Homicide is the killing of a human being of any age or sex, and is of three kinds: murder, manslaughter, and justifiable homicide. Code Section 4253. Murder is the unlawful killing of a human being in the peace of the state by a person of sound memory and discretion, with malice aforethought, either express or implied. Code Section 4254. Express malice is that deliberate intention unlawfully to take away the life of a fellow creature, which is manifested by external circumstances capable of proof. Code Section 4255. Malice shall be implied where no considerable provocation appears, and where all of the circumstances of the killing show an abandoned and malignant heart. Code Section 4256. Manslaughter is the unlawful killing of a human being without malice, either express or implied, and without any mixture or deliberation whatever, which may be voluntary upon a sudden heat of passion, or involuntary in the commission of an unlawful act, or a lawful act without due caution and circumspection. Code Section 4258. In all cases of voluntary manslaughter, there must be some actual assault upon the person killing, or an attempt by the person killed to commit a serious personal injury on the person killing. Provocation by words, threats, menaces, or contemptuous gestures shall in no case be sufficient to free the person killing from that crime and guilt of murder. The killing must be the result of that sudden, violent impulse of passion, supposed to be irresistible. For if there should appear to have been an interval between the assault or provocation given and the homicide sufficient for the voice of reason and humanity to be heard, the killing shall be attributed to deliberate revenge and be punished as murder. Code Section 4259. Involuntary manslaughter shall consist in the killing of a human being without any intention to do so, but in the commission of an unlawful act, or a lawful act which probably might produce such a consequence in an unlawful manner, provided always that where such involuntary killing shall happen in the commission of an unlawful act, which in its consequences naturally tends to destroy the life of a human being, or is committed in the prosecution of a riotous intent, or of a crime punishable by death or imprisonment in the penitentiary, the offense shall be deemed and adjudged to be murder. Code Section 4261. Justifiable homicide is the killing of a human being by commandment of the law, in execution of public justice, by permission of the law, in advancement of public justice, in self-defense or in defense of habitation, property, or person, against one who manifestly intends or endeavors by violence or surprise to commit a felony on either, or against persons who manifestly intend or endeavor in a riotous or tumultuous manner to enter the habitation of another for the purpose of assaulting or offering personal violence to any person dwelling or being therein. Code Section 4264. A bare fear of any of these offenses, to prevent which the homicide is alleged to have been committed, shall not be sufficient to justify the killing. It must appear that the circumstances were sufficient to excite the fears of a reasonable man, and that the party killing really acted under the influence of those fears, and not in a spirit of revenge. Code Section 4265. If, after persuasion, remonstrance, or other gentle measures used, a forcible attack or invasion on the property or inhabitation of another cannot be prevented, it shall be justifiable homicide to kill the person so forcibly attacking or invading on the property or habitation of another. But it must appear that such killing was absolutely necessary to prevent such an attack and invasion, and that a serious injury was intended or might accrue to the person, property, or family of the person killing. Code Section 4266. If a person kill another in his defense, it must appear that the danger was so urgent and pressing at the time of the killing that in order to save his own life, the killing of the other was absolutely necessary. It must appear also that the person killed was the assailant, or that the slayer had really and in good faith endeavored to decline any further struggle before the mortal blow was given. Code Section 4267. All other instances which stand upon the same footing of reason and justice as those enumerated shall be justifiable homicide. Code Section 4268. You will, in the first place, inquire from the evidence whether the deceased came to his death at the hands of the prisoner, or in case he did not, whether he was slain by Charles A. Kelly, and the prisoner was present, aiding and participating in the acts of Charles A. Kelly that caused his death with like intent. For where two or more persons acting together with a common intent and purpose are present at the commission of a crime, though the deed may be wrought by the hand of one alone, all who are present aiding, abetting, or giving countenance to it are alike guilty. The law makes no distinction between them. Any act done by one of the party in pursuance of the common purpose and with reference to it is, in contemplation of law, the act of all, and proof of such act is evidence against any or either of the others who were engaged in the combination. To make out the guilt of the one who, in fact, did not strike the mortal blow, it is necessary that the proof should show that he was acting in concert with him who did, moved by a common intent and purpose. It is not necessary that an actual verbal agreement or understanding between the persons should be proved. Such concert of action or intention may be inferred from joint acts, coupled with circumstances which would show that they were engaged in the same act with the same intent. Presence and participation in the act committed is evidence from which the jury might infer consent and concurrence. If you should find from the evidence that the prisoner himself fired the shot which killed deceased, or that Charles A. Kelly did it and prisoner was present, acting in concert with him, moved by the same design with common intent and purpose, your next inquiry will be as to the grade of the homicide, and first, whether the facts and proof are sufficient to bring it under the definition of murder. That is, whether the deceased was killed with malice aforethought, either express or implied. Express malice, as I have shown you, is the deliberate intention to take away the life of a fellow creature, manifested by circumstances capable of proof. And the law declares that malice shall be implied when no considerable provocation appears, and where all of the circumstances of the killing show an abandoned and malignant heart. This is a question for your exclusive determination under the law, and in coming to a conclusion thereon, you should consider all of the evidence before you, elucidating the acts and the motives of the parties engaged in this unfortunate affair, the circumstances attending and surrounding the homicide, a place where it occurred and the manner of its occurrence, the necessity of its commission, or the recklessness with which it was committed, if there should be evidence of that fact, the want of provocation or the justification thereof, are all to be considered as they are severally established or disproved by the evidence, by you in determining the question of malice. The fact that a man goes armed, contrary to law, prepared for any emergency, is proven, is a circumstance from which the jury may infer malice, and it is contrary to law for any person to have or carry about his person any pistol except a horseman's pistol, unless he carries it in an open manner and fully exposed to view. And since the act of 18th October, 1870, it is against the law of this state for any person to carry about their person any dirk, bowie knife, pistol, or revolver, or any kind of deadly weapon, to any court of justice or any election ground or precinct, or any place of public worship, or any other public gathering in this state except militia muster grounds. The use of a deadly weapon by a person in an assault upon another is evidence of malice and felonious intent. The wanton and reckless discharge of firearms into a large crowd, if without sufficient provocation to justify it, is also an evidence of malice. The want of sufficient provocation to justify the killing is also an evidence of the existence of malice. All of these, however, and any other evidence of malice may be rebutted by showing a sufficient provocation on the part of the person killed to justify the killing, or reduce it to a lower grade of homicide. But there must be an actual assault or some considerable provocation, other than by words, threats, menaces, or contemptuous gestures, to reduce the offense from murder to manslaughter. If an assault or such provocation exists, and there is not a sufficient interval between the assault and such provocation for passion to cool, and the voice of reason and humanity to be heard, the offense is reduced to voluntary manslaughter. But if there is no such assault, or other considerable provocation equivalent to justify the killing or reduce its grade, then the slayer is guilty of the highest offense, murder. You will look into the evidence, and from the facts and proof determine this question. But if the facts and proof are not sufficient to make it a case of murder, then inquire whether it be manslaughter, and you will observe the great distinction between murder and manslaughter is that the first is accompanied by malice, either express or implied, and the latter is not so accompanied, nor by the least degree of deliberation. For the least deliberation involves malice, and makes it murder. Every case of homicide not accompanied by malice, express or implied, is a case of manslaughter or justifiable homicide. Manslaughter differs from murder in the important particular of the absence of malice, as when it happened in a sudden heat of passion, when passion has obtained dominion over reason and the gentler feelings of the heart. From a respect to human infirmities, the law in such cases mitigates the offense and reduces it from murder to manslaughter. Still, this is unlawful, the law not permitting any man to avenge his own wrongs, either real or fancied, by killing the supposed offender, unless in cases of great emergency. There must be some actual assault on the person killing, or an attempt by the person killed, or some considerable provocation by him other than provocation by words, threats, menaces, or contemptuous gestures. And the killing must be the result of that sudden, violent heat of passion, supposed to be irresistible under such assault, such attempt, or such considerable provocation, to reduce the offense from murder to manslaughter. But if there be no such assault, no such attempt, or no such considerable provocation, the offense is murder. And manslaughter if there was an actual assault by deceased, or an attempt by deceased to commit a serious personal injury on prisoner, or his brother, Charles A. Kelly, or if the deceased gave prisoner considerable provocation, and before his passions had time to cool and subside. If prisoner, under such circumstances, killed deceased himself, or participated with Charles A. Kelly under such circumstances, with a common intent and purpose, he is guilty of voluntary manslaughter. Examine the evidence and see whether the offense comes under that definition, and go further and see whether it falls under the next grade of homicide, which is involuntary manslaughter, and is defined by law to be the killing of a human being without any intention to do so, but in the commission of an unlawful act or lawful act, provided always that where such involuntary killing shall happen in the commission of an unlawful act, which in its consequences naturally tends to destroy the life of a human being, or is committed in the prosecution of a riotous intent, or of a crime punishable by death or imprisonment in the penitentiary. the offense shall be deemed and adjudged to be murder. So you will perceive that the killing of a person without any intention whatever to do so may amount to the highest grade of homicide, murder, in certain cases, when the act that causes death is of itself unlawful, or the death is caused by one in the prosecution of a riotous intent, or in the course of the commission of another crime which might subject the perpetrators to punishment by death or imprisonment in the penitentiary. After which you may examine by the proof whether it falls under the third grade of homicide, which is justifiable, and is defined by law to be, first, when the killing is by commandment of law and execution of public justice, as when an officer executes a criminal pursuant to the sentence of the law. Second, in advancement of public justice, as when an officer in the due execution of his office kills a person who resists or assaults him. Third, in self-defense, against one who manifestly intends or endeavors to commit a felony upon the person killing, or someone that he, by natural ties, as kindred, or by legal permission, as of one under his protection, he has the right to defend under the same circumstances, but the intent of the aggressor must be to commit a felony, which is defined by law to be any crime which is punishable by confinement in the penitentiary or capitally. If the intent or endeavor of the aggressor is only to commit a trespass, as to beat the party, it will not justify the killing of the aggressor. The assault or the trespass, as above described on the person killing, may reduce the offense from murder to manslaughter, but cannot justify the killing. To authorize the killing and make it justifiable homicide, it must be an attempt to commit a felony as above described, or on the habitation or property of the slayer, or against persons acting in a riotous and tumultuous manner. The sections of the code which I have read to you relate to the right of self-defense, and they constitute the law which must govern you in the determination of this branch of the case. The right of self-defense is given by sections 4264, 4265, and 4266 against one who manifestly intends or endeavors by violence or surprise on the habitation, property, or person of another. This right is limited by section 4265, which requires that the circumstances to justify the killing must be sufficient to excite the fears of a reasonable man, and that the party killing really acted under the influence of those fears and not in a spirit of revenge. And the 4267 section still further limits it by saying that it must appear that the danger was so urgent and pressing at the time of the killing that in order to save his own life, the killing of the other was absolutely necessary. And it must appear also that the person killed was the assailant, or that the slayer had really or in good faith endeavored to decline any further struggle before the mortal blow was given. And section 4268 places all other instances which stand upon the same footing of reason of justice as those enumerated upon the same foundation, and holds such instances to be cases of justifiable homicide. I have been thus full and explicit in giving you the laws in charge concerning homicide, from the fact that it may become necessary for you, in making up your verdict in this case, to come to a conclusion, not only in reference to the acts of the prisoner himself, but the acts of Charles A. Kelly, and those acts not only in connection with the deceased, but in connection with other parties, as of Ames and those persons who were in company with him. If the shot which caused the death of the deceased was discharged at Ames or other persons, and at the time it was so discharged, Ames or the other persons at whom it was aimed was endeavoring by violence or surprise to commit a felony on the habitation, property, or person of prisoner or his brother, and if prisoner acted under circumstances sufficient to excite the fears of a reasonable man, and was influenced by those fears and not by a spirit of revenge, and if, at the time the shot was fired, The danger was so urgent and pressing that, to save his own or the life of his brother Charles, the firing was absolutely necessary, and the shot accidentally missed the person or persons aimed at and caused the death of deceased without any intention on the part of John R. or C.A. Kelly firing it, then the prisoner was justifiable, and you should acquit him. But if there was no such attempt to commit a felony on the habitation, property, or person of prisoner or his brother by any person, and there was no reasonable ground to fear such an attempt, and the danger was not so urgent and pressing that, in order to protect his own or his brother's life, the firing of the pistol was absolutely necessary, or if the circumstances attending the firing of the pistol, which caused deceased death by prisoner, if he did it, or by Charles A. Kelly, if he fired it, and prisoner was present participating in the act with the common intent and purpose, does not place this case upon the same footing of reason and justice as those enumerated. He was not justifiable. You will take into consideration all of the facts as proven by the witnesses in this case. Scan those facts under the rules which the law has prescribed for your guidance, and which I have given in charge to you, and say of what crime the prisoner is guilty, if he is guilty of any. If you are satisfied beyond a reasonable doubt that the part taken by him in the acts which caused the death of Oxford makes him, under the law, guilty of murder, so find him. If voluntary manslaughter, so declare. If of either of the grades of involuntary manslaughter, so let your verdict be. If a case of justifiable homicide, acquit him. If the circumstances in proof are such as to raise a reasonable doubt in your minds as to his guilt, acquit him. Though you may have no doubt of the guilt of Charles A. Kelly, yet if you have a reasonable doubt the prisoner aided or participated in the act of Charles with a common design or like intent, acquit him. But the doubt must be reasonable doubt. It must not be assumed to be used as a pretext for acquitting the prisoner, but must actually exist, and must arise from such a state of facts as to leave the mind in doubt on which side the truth lies. The want of, or the insufficiency of testimony to produce moral certainty on the mind of the jury. When such doubts exist, the humanity of the law gives the accused the benefit of it and acquits him. If, as to the grade of the offense, that is, whether it be murder or voluntary manslaughter, or either of the grades of involuntary manslaughter, give him the benefit of the doubt attached to that grade, wanting in moral certainty, and find him guilty of the next lower one, upon which there may be no doubt. If you should come to the conclusion that the prisoner is guilty of the offense with which he is charged, the form of your verdict will be, we, the jury, find the accused John R. Kelly guilty. If you think him guilty of either of the grades of homicide, express in your verdict of what grade he is guilty. If you think that he is not guilty, say, we, the jury, find the accused John R. Kelly not guilty. The verdict. The jury retired, and after being out 1 hour, returned into court the following verdict. We, the jury, find the defendant John R. Kelly guilty of voluntary manslaughter. End of section 95. Section 96 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of John R. Kelly for the murder of David W. Oxford, Dawson, Georgia, 1871, Part 12. The escape from prison. It was 3 o'clock in the morning when the jury returned its verdict, and the prisoner was remanded to jail to await his sentence, and a guard placed over the premises. About 9 o'clock, or after the guard had been removed, John and his brother Charles, who had been committed a few weeks before, succeeded in forcing the window of the prison and made good their escape. Footnote: broke jail. Charles A. and John R. Kelly, who had been convicted of the crime of manslaughter on the body of David W. Oxford, broke jail on Sunday morning last. They were placed in jail on Saturday night last with a guard around them. The jailer, thinking it useless to keep the guard on duty during the day, they were released, and about 9 o'clock in the morning the prisoners made their escape. The other inmates of the jail testified that it was not exceeding 15 minutes from the time they commenced to get out until they were perfectly free, which shows the worthless condition of the jail. The Dawson Journal of June 1st, 1871. The attention of this body was called to the escape of Charles A. and John R. Kelly from the county jail on last Sabbath by a special charge from His Honor Judge Harrell on last Monday morning, and orders and instructions given, and all aid offered that might be needed to ferret out the cause of their escape, and to look into the acts of the officers, and see if negligence on their part was the cause. We beg to report that we have diligently inquired into the matter, and conscientiously labored to get evidence that would enable to detect a wanton or willful violation of orders, or neglect of duty on the part of the officers of the county, but have not been able to do so. We, nevertheless, believe that the jailer did not do his full duty. We attach no blame or censure on Mr. Kegler, sheriff of the county, for willful neglect of duty in the discharge of the guard around the jail in the day. We recommend that the proper officer of the county offer a reward of $1,000 for the apprehension of the parties, or $500 for either one of them, and respectfully suggest to His Excellency Governor Bullock the propriety of offering a liberal reward for the apprehension and delivery in any jail of the state of the said John R. and Charles A. Kelly. Presentment of the Grand Jury of Terrell County, May term, 1871. In the afternoon, when Colonel Ames was found to be mortally wounded, he made his will bequeathing $50,000 to his wife and $100,000 to his father and brother George, and gave directions that the circus should go on and fill all the season's engagements. Everything was done by the citizens of Dawson to render him comfortable while in life, and after his decease, a committee of the town council accompanied his remains to Macon, where they were interred. The following letters help to explain the failure of the prosecution for his killing. They were written by the Solicitor General to the wife and father of the victim. No reply could be obtained to either. Macon, Georgia, February 7th, 1871. Mrs. C.T. Ames, New Orleans, Louisiana. Dear Madam, you have doubtless heard the result of the trial of John R. Kelly in Terrell County last November for the killing of C.T. Ames, your late husband. His acquittal was attributed, in a great measure, to the indifference manifested by the friends and relatives of the deceased to the result of that trial. Had they taken one half the interest in the prosecution that the friends of the accused did in the defense of that case, the result would have been different. While the friends of Colonel Ames employed no counsel to prosecute, leaving the whole management to the Solicitor General, the defendant employed the ablest counsel in the vicinity to defend him. Against the array of legal talent thus brought forward, the state's prosecuting officer of that circuit was powerless to convict, while the relatives and friends of Colonel Ames stood aloof, took no interest in the matter whatever, did not even attend the trial. The immediate friends and family of the accused were at work, from the day of the homicide to the day of the trial, and during the trial, using all their efforts to ensure an acquittal. He was acquitted for these reasons, and not because the people of our state are indifferent of human life, and do not wish to see the violators of her laws punished. After John R. Kelly had been acquitted, the Solicitor General asked to be excused from prosecuting Charles A. Kelly on account of a near relationship between the wife of the accused and his own. On that account, the second Kelly was not tried at the same term. A court is to be held in that county on the first Monday in March, when the other Kelly will be put upon trial. In order that the laws may be vindicated and the violators thereof punished, the governor of the state of Georgia has seen fit to appoint myself as its prosecuting officer in that particular case. This has been done upon the recommendation of the presiding judge. First, because I practice regularly in that court and am extensively acquainted there. Second, because of my familiarity with the facts, by reason of my taking down the testimony upon the trial, which has already taken place. It is because I have been thus appointed to represent the state of Georgia, and to do what in my power lies to vindicate her laws, that I now address you. In the trial of the other case, though a simple spectator, having no interest in the matter, other than such interest as was felt in common with every law-abiding citizen, I saw that it was unfortunate for the state that it went to trial without the evidence of some of Colonel Ames's men, who were with him on that unfortunate occasion, and who witnessed the whole difficulty, from its commencement to its bloody close. All the witnesses were citizens, and there was a great conflict in their testimony, for while most of those sworn for the state testified that the only persons who fired shots on that lamentable occasion were the prisoners, others, sworn on behalf of the defense, were equally positive that Colonel Ames had a pistol in his hand, held in a threatening attitude, and that some one of the showmen commenced the row by firing the first shot in the direction of the Kellys. Now what I wish is this. I want at least 3 of those men at the next trial, if they are upon the top of the earth. It is all important that I should have their evidence. Important because the good name of the state of Georgia is involved. Important that crime, one of the highest crimes known to our laws, may be punished. Important that the memory of the dead victim of that unfortunate and unnecessary affray may be washed of the stain cast upon it by the evidence of the former trial, which made him the assailant. I want as witnesses, first, the treasurer of the company, who was in the ticket wagon when Colonel Ames left it to suppress the row at the door of the sideshow, and who doubtless witnessed the whole affair. Second, the 2 men who were with Colonel Ames and who, the witnesses for the state testified, were assisting him to get under the canvas, while the Kellys were firing upon him and those who were assisting him. One of the state's witnesses testified that he was looking at the 3, that Colonel Ames was down on his left hip and arm, helping himself along while the other 2 men were assisting him. One of them had hold of Ames's right arm, helping him, that Ames's back was to the men firing upon him, and that the fire was so rapid and so near to them that he expected every moment to see the whole 3 go down under it. I think you owe it to yourself, to the memory of your dead husband, and to the vindication of a violated law, to get these witnesses and send them here, so that I may have the benefit of their testimony on the next trial. If they come, I want them to report to me here in Macon by the Saturday before the first Monday in March, 4 days. I want them to come incognito, to let no one know their business. Let the defendant take alarm and put off his trial. I wish to keep them in Macon until the trial is in progress, and so far advanced that it cannot be arrested. Then, at the proper time, telegraph them to come down and put them on the stand, and thus, I think, ensure a conviction. Hoping to hear from you soon, I remain yours very respectfully, Samuel D. Irvin, Solicitor General Pro Tem, State of Georgia. John Ames, Esquire, Syracuse, New York. Dear Sir, I enclose herewith a rough copy of a letter I addressed to Mrs. C.T. Ames, February 7th last, and mailed to New Orleans, Louisiana, which letter she received, but from that time to the present moment I have no response from her. That copy letter will inform you of my purpose in addressing her, and I beg leave to state in advance that I have the same object in thus addressing you. We are strangers to each other, and I do not wish to do you any injustice in thought or deed. Your conduct in connection with that of the woman who bore the name of your son, while in Georgia, has been to me inexplicable. You permitted your son's death to pass as if he had not sprung from your loins. You had reasons for your course, I suppose satisfactory to yourself, but our whole people have been astonished at the utter indifference manifested by all who were connected with that unfortunate man. Not one of you were at the trial of his murderers. No counsel was employed by you to aid in the prosecution, although he left you the accumulations of his life, including the proceeds of that exhibition in Dawson, which cost him his life. How could you expect strangers to take such an interest in the matter as to ensure the conviction and punishment of his slayers, when you were so remiss in your duty? This is the view that every unprejudiced mind must take of your conduct, but I do hope that you had good, valid, justifiable reasons for your course. At the court held on first Monday in March, I indicted the two Kellys for the murder of D.W. Oxford, a citizen, killed at the same time. I tried C.A. Kelly on that bill of indictment and convicted him of voluntary manslaughter, which is only one grade below murder. He had previously continued the case against him for the murder of C.T. Ames. He will be tried for that offense at the court commencing 4th Monday in May, 22nd day of the month. I say to you, as I said to Mrs. Ames, I must have certain witnesses, if they are on top of the ground. The treasurer who was in the ticket wagon, and the two men who were assisting your son to get under the canvas from the fire of the assailants' pistols. I want you also as the father of the murdered man, that I may have at least the moral support of your presence, and to counteract the influence upon the sympathy of the jury, occasioned by the presence of the gray-haired father of the prisoner. You can get these witnesses. You can at least afford to pay their expenses here. You can do that much at least for the cause of justice and to vindicate the memory of your poor unfortunate son. The state of Georgia has appointed me to prosecute. I feel myself, with my knowledge of the facts, fully competent for the task. I ask you to incur no expense in feeing counsel. I ask for no associate counsel, would not accept their aid if you were now to employ them. The state will pay me for my services, and hence all I ask of you and all that is necessary for you to do is to procure the witnesses I have named. I do not know their names, but you do, or can find them out. George Ames, your son who was along with the circus at that time, can find them. I want them to come to Macon that I may consult with them. Let them reach here by the 20th of May. Keep their own counsel so that no one may know of their presence until I choose to let it be known. If they have any fears for their safety, as they need not have, I will give them a safeguard under the broad seal of the state of Georgia, and ensure that they shall not be molested while here, and be permitted to return as soon as they have testified in the case. In conclusion, permit me to say in all kindness that you must not treat this request with the indifference that woman has manifested towards the one addressed to her. If you do, the United States shall ring with the infamy of a father who would not do anything to bring the murder of his son to justice, when that son, upon his dying bed, bequeaths to that father the means which would have enabled him to accomplish that purpose without feeling the outlay. Hoping to hear from you soon, and craving your pardon if I have said anything to wound your feelings, I remain yours truly, Samuel D. Irvin, prosecuting officer of the state in said case. P.S. Conviction is certain with the evidence I am seeking. S.D.I. End of footnote. End of section 96.
Section 97 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. The Trial of Thomas Ward for the Killing of Albert Robinson, New York City, 1823. Part 1. The Narrative. In the busiest part of New York City, nearly a century ago, people were returning home from their work in the twilight, and the streets were crowded with carts and wagons. A pedestrian at a crossing, evidently thinking that a cart was going to be driven over him, seized the horse by the head, which caused it to turn suddenly, almost throwing the cartman Ward into the street. He recovered himself, seized a heavy stick which was in the cart, and threw it at the pedestrian. It missed him, but he picked it up and was about to attack Ward with it when the latter jumped from his cart, wrested it from his hand, and struck him over the head with it. The man fell to the ground unconscious, and a few days later died from the effects of the blow. Tried for manslaughter, the cartman was acquitted, the jury taking the view that the blow was struck in self-defense. The Trial. In Court of General Sessions of New York City, November 1823. Honorable Richard Riker, Recorder. November 18. The prisoner was charged in an indictment for manslaughter with having willfully and feloniously killed Albert Robinson by a blow inflicted on the 17th of October last on his temple by the rung of a cart. Ward was a young man of good appearance and respectable deportment, apparently about 26 years of age, and by occupation a cartman. Hugh Maxwell, District Attorney for the prosecution. John L. Graham, Dr. John A. Graham, William M. Price, and John Anthon for the prisoner. Footnote: Graham John Lorimer, 1797 to 1876, born London, England, son of Dr. John A. Graham, who early in the 19th century was a practitioner in the New York criminal courts. Studied law with Judge Reeve of Litchfield, Connecticut. Called to the bar 1821. Became wealthy in the practice of his profession. Regent State University 1834. Postmaster, New York City 1840 to 1844. End of footnote. Mr. Maxwell opened the case and made an exposition of the facts he expected to prove and of the law as applicable to them. The witnesses for the people. Dr. Marinus Willett, Jr., Emma surgeon of the New York hospital to which the deceased was taken, examined the head of Robinson, found little evidence of serious injury on the external part of it. There were symptoms, however, of a compression of the brain, and there was a bruise over the right eyelid, extending from above the temple about 3 inches down upon the cheek, which might have been produced by a blow. He was brought in on the evening of Saturday, and on Sunday evening the operation of trepanning was performed by Dr. Mott. The skull was found to be fractured, but not so badly, but the patient had no other injury existed, might have recovered by the application of ordinary remedies. His death, about 3 on Monday morning, was occasioned not by the fracture, but by the rupture of a blood vessel, the artery of the dura mater, and the extravasation of blood on the brain. believe the blow occasioned the death. Peter Boggart, Emma Cartman, was returning home on the evening of the affray between 6 and 7 o'clock. Not very dark, but the lamps were lighted. 3 carts were passing down Chambers Street, the first Ward's, the second Fash's, and the third mine. Observed Robinson passing down the flagging, which is laid transversely from the corner of Chamber and Chapel to the east side of Hudson Street. He had a tin kettle in his hand and was going the same way with Ward. About 2 feet of Ward's cart, who was upon a walk, he turned around and seized his horse by the head with his left hand. The horse sprung from him and turned upon the sidewalk, nearly throwing Ward from his cart. Ward was very near the sidewalk at the time, and he was turning into Chapel Street and deceased into Hudson Street, where those streets form an acute angle. The further they advanced, the less they were incommoded by each other. When Robinson took hold of the horse's bridle, Ward laid hold of his monarchy and threw it at him. Footnote: monarchy is a Dutch word and was explained to mean a forerung of the cart to which the lines were occasionally made fast. About 3 feet long, 3 inches by 2½ in thickness at the bottom, and lessening almost to a point at the top, usually made of oak or hickory. End of footnote. The monarchy did not hit deceased, but he picked it up, drew it across his shoulders with both hands in a threatening attitude towards Ward, as if he intended to strike him. Ward's cart, however, had at this time so far advanced that he was not within striking distance. Almost simultaneously, Ward stopped his horse, stepped to the tail of his cart, sprang from it towards Robinson, and in a scuffle wrestled the monarchy from his hand, shoved him back a foot or 2, and with both hands hold of the instrument, knocked him down with it by a blow on the right side of the head. At the moment of striking, Ward said, "You damned son of a bitch, a little more and you would have thrown me from my cart." The word and the blow seemed together. Never knew an affray more rapid from its commencement to its conclusion. It seemed the transaction of a moment. Robinson fell, and Ward jumped upon his cart, taking the monarchy with him, passed on about 25 feet, then stopped, hooked his wheel, and came back. But seeing Mr. Ryder with the man up, he again mounted his cart and drove off. Cross-examined. I knew neither Ward nor Robinson previous to the transaction. Ward had a leather trunk and a roll of carpeting on his cart at the time. Deceased had no offensive weapon, but was in no danger from Ward's horse, which when seized was quite restive. When Ryder took up the deceased, he called him by name, and also spoke to the prisoner and said, "Ward, for shame, you ought not to strike a man so." Could not say whether Robinson was intoxicated or not, nor for what reason he seized the horse. He was knocked down by the side of my cart, very quick. The whole was almost one act. Robinson picked up the monarchy by the wheel. He was a stouter man than Ward. Daniel Fash, Emma Cartman, was following Ward's cart at the time of the affray. Confirm the statement made by Boggart. Saw the monarchy thrown at Robinson by Ward. It flew over his head about 2 feet. Cross-examined. Remained at the place until Mr. Ryder had raised up deceased. The hat of deceased was not struck off by the blow. As I was going down Hudson Street and Ward down Chapel, it brought Robinson between our carts, but the further off, as they progressed, as the streets diverged in different directions. Richard G. Ryder, Emma Cartman, came up just at the time Robinson held the monarchy in his hand in an attitude of hostility to Ward, saw Ward strike with the stick. It was but one blow. The man fell, and I jumped off to his relief. Found it was Robinson, whom I knew, and seeing that the person who struck him was prisoner, whom I also knew, I cried shame to Ward. Robinson laid lifeless as a log and totally insensible. Ward moved off a few feet, where he remained. I raised up deceased and asked him if he knew me. He nodded assent, helped him across the street, washed the blood from his face, and, at the insistence of a young gentleman who came up, bathed his wounds with spirits. Deceased then jumped upon his feet, refused to be carried home by me on my cart, jerked away, and said he could go home alone. Acted as if he was intoxicated, for he went down Chambers Street, which was not his way home. Had known deceased 12 or 14 years. Heard Ward only say in reply to my statement that a cartman had struck deceased with a rung of his cart, that it was not with his rung, but with his monarchy. Ward gave no indications of regret. Have known him about 18 months. Consider him a mild and worthy man. Robinson formerly drove a cart. He did not speak until his head had been washed in spirits. Dr. Willett recalled. A piece of fractured bone was removed. The rupture of the blood vessel could not have been occasioned by the trepanning, for the blood on the brain was not only extravasated, but coagulated. End of section 97. Section 98 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Thomas Ward for the killing of Albert Robinson, New York City, 1823, Part 2. The Defense. Robert Castle, deceased, appeared to be intoxicated in the afternoon of the affray. Peter Nadine and Joseph Archer testified that he was a bad-tempered man, passionate, perverse, and occasionally intemperate. Ralph Olmsted, Robert Hyslop, Rufus L. Lord, Henry Hepburn, Charles Squire, Calvin W. Howe, and Allen C. Lee, all merchants in the city, had been acquainted with the prisoner for 3 years past. He had uniformly manifested a mild and amiable disposition, rather timid than quarrelsome, and more disposed to yield than rigorously assert his rights. He was uniformly temperate, courteous, and obliging, industrious and honest, and supported by his labor, a mother and 2 or 3 sisters. Dr. Jeremiah D. Fowler, lived at Mount Pleasant, the birthplace of prisoner, had known him about 17 years, and from a boy. His disposition always appeared to be mild and good, and his connections in Westchester were respectable. Robert K. Foster, have known prisoner from 1810 to 1816, during which time he was an apprentice to me. He possessed the best disposition of any apprentice I ever had. Emma Shoemaker, prisoner, served out the full time of his engagement without indentures. Dr. Richard L. Walker considered trepanning a dangerous operation. Patients often die from the inflammation occasioned by it who might have recovered from the injury it was intended to remedy. The coagulated blood referred to by Dr. Willett might have been occasioned by exposure to the air, nor would its coagulation prevent it from being absorbed. Cannot decide with certainty, even had I performed the operation myself, whether the death was occasioned by the monarchy or the trepanning. Did not see the patient. Have known a rupture of a blood vessel from extreme passion. Persons of violent temper are liable to apoplexy from a surge of blood to the head. Dr. Valentine Mott performed the operation of trepanning the deceased in the hospital. His head was broken and his death was occasioned by the injury and not by the trepanning. Mr. Anthon and Mr. Price addressed the jury, stating the laws of manslaughter and self-defense as set out in the books. Dr. Graham, gentlemen of the jury, the Almighty, of his infinite goodness, has given to one man 10 talents, to another 5 talents, and to a third 1 talent. If I were to bury my talent in the earth, or lock it up on this occasion, I should not only do great injustice to the prisoner at the bar, but should also consider myself as sinning against the bounty of Providence. Therefore, as one of the counsel for the prisoner, I shall now have the honor of addressing you in his behalf. The prisoner is indicted for the crime of manslaughter in causing the death of Albert Robinson by giving him a blow on the right side of the head with a stick attached to his cart, commonly called a manaki, on the evening of the 17th of October now last, to which charge the prisoner has pleaded not guilty, and put himself upon God and you, gentlemen of the jury, for trial. I congratulate the prisoner and the public that the Constitution and laws have wisely placed in your hands the trial of this cause, knowing, as I do, the character of our New York jurors being proverbial for wisdom and sound discretion, lovers of liberty, humanity, and justice, and, generally speaking, men possessing undeviating integrity and of high and delicate honor. Having with great deliberation examined and considered the law and the facts, the principles which ought to govern in this case, and the tribunal which is to decide the fate of the prisoner, I have made up my opinion and fear not the final results. Of the law as well as of the facts, you are the judges, and I shall draw on you, for my client, your verdict of acquittal. As discreet men, jurors, you will always pay the greatest deference and respect to what may fall from the lips of a learned judge, especially when it comes from one whose life has been devoted to philosophical and juridical studies. But remember that the greatest lawyers and the greatest judges often differ in opinion as much as in their looks on the subject of homicide, which, by the books, is divided into 3 kinds: justifiable, excusable, and felonious. I contend that instead of the prisoner having been guilty of manslaughter as charged in the indictment, the act is excusable homicide, se defendendo, or in self-defense. To establish my defense for the prisoner, I shall confine myself principally to the law and the facts, since eloquence is necessary to defend a bad cause, and a good one may easily be supported by the logic of common sense and the rhetoric of unstudied expression. Gentlemen, time, place, and provocation are all important in the investigation. Thereupon hangs the very gist of this indictment, and this case, like all others, must stand or fall on its own merits. The learned counsel associated with me have read to you the law from Blackstone, Hale's Pleas of the Crown, East's Crown Law, and some other authorities which ought to govern in this case. I subscribe fully to the doctrine by those gentlemen so ably, forcibly, and eloquently contended for, whatever may be the opinion of the court to the contrary. Let me call your attention to the two great laws of human society from whence all the rest derive their course, force and obligation. They are those of equity and self-preservation. By the first, all men are bound alike not to hurt one another. By the second, all men have a right to defend themselves. The civil law says, it is a maxim of the law that whatever we do in the way, and for the ends of self-defense, we may lawfully do. This principle of the civil law has been fully recognized in the 5th section of the Act, passed the 14th of February, 1787, by our legislature, declaring that persons killing in self-defense or by misfortune shall be therefore fully acquitted and discharged. All the laws of society are entirely reciprocal, and no man ought to be exempt from their force, and whoever violates this primary law of nature ought by the law of nature be destroyed. He who observes no law forfeits all title to the protection of the law. It is wickedness not to destroy a destroyer, and all the ill consequences of self-defense are chargeable upon him only who occasioned them. To allow a license to any man to do evil with impunity is to make vice triumph over virtue, and innocence to prey to the guilty. The law of nature does not only allow us, but obliges us to defend ourselves. It is our duty not only to ourselves, but to society. If we suffer tamely a lawless attack upon our person, property, and fortunes, we encourage it and involve others in our doom. And Cicero says, he who does not resist mischief when he may, is guilty of the same crime as if he had deserted his parents, his friends, and his country. So that the conduct of my client in defending his person and his property against the unlawful and wicked attack of the deceased is, I contend, excusable homicide in self-defense, by all laws human and divine. Again, the motive from which an action springs ought never to be overlooked, and it would be against natural justice to condemn a man to punishment for what is owing rather to his misfortune than his fault. The prisoner could have had no motive but merely to defend himself and his property. The deceased, a total stranger to him, seized his horse by the head and stopped him on the public high road when my client was in the peace of God, in the peace of the people of the state of New York, and about his lawful business. This is a very important fact, and calls for the most serious consideration, and it ought to be most carefully weighed by every juror on the panel. Suppose either of you, gentlemen, had been stopped on the high road just at the dusk of the evening by a stranger, as was the prisoner by the deceased, your property seized by force, your person most grievously insulted and injured, and you had no alternative but to submit to the insult and outrage. or by defending yourself and property against the mischief intended you. Your own good sense and knowledge of cause and effect will instantly give the answer. The counsel who preceded me in summing up this cause having gone minutely into the testimony, I shall not trespass on your time by recapitulating the evidence, as the same must be fresh in your minds. I would ask, then, can you consign to a state's prison for years a worthy citizen who, unfortunately, to save himself and his property from destruction, was driven of necessity to give the blow which has since proven the death of a man whom the prisoner believed at the time was a lawless desperado? The prisoner deeply laments the deceased, but he feels no remorse, no disquieting dread of God or man, because his conscience whispers to him that what he did on that occasion was only in self-defense. The Honorable the District Attorney, in withholding from the jury the examination of the prisoner taken in the police immediately on his arrest, I must say, notwithstanding my friendship and esteem for that gentleman, does not comport with my idea of justice and humanity, and to my mind it is self-evident that Mr. Maxwell intends to press all sail that he possibly can to convict the prisoner. I therefore most earnestly request of you to banish from your ears the charms of his eloquence, and with your oaths upon your consciences, make to this tribunal and your God your solemn verdict. Gentlemen, in the name of your own interest, your own honor, and your own glory, I call upon you, by your verdict, to pronounce judgment on yourselves, because a singular misfortune may some day, by the providence of God, happen to some of you. If the authorities and arguments my learned associates and I have used have not been convincing, you would not be convinced though one should arise from the dead. Justice and humanity revolt at the idea of a verdict of guilty against the prisoner, and should you, by your verdict, pronounce the horrible word guilty, I should blush over this departure from those characteristic features of moral rectitude in the gentlemen who fill the panel, and tremble at the impending vengeance which awaits your future destiny. Mr. Maxwell argued in behalf of the people. The recorder charged the jury, in which the prominent facts were recapitulated, and the law relative to manslaughter, and the distinction between it and chance medley in self-defense was stated and explained with precision and perspicuity. The jury, in about 2 hours, returned a verdict of not guilty. End of section 98. End of American State Trials, Volume 4, by John D. Lawson.